All right, my beautiful friends. I just pressed the Let's Go Live button on our end over here, and so that means we got to wait for the tubes to connect themselves. It's a little bit unusually early for us here, and so sometimes those tubes want to go back to bed. They want to press the snooze button and say, it's too early for us here. We haven't warmed up our tubes yet. 7 a.m. here in Arizona. Of course, we are here waiting for Judge Scott McAfee to get us started on a motions hearing in Georgia. And boom, the proceeding is live and well. They went live the same time we did. Right on the money, baby. Okay, so we're paying close attention. One of the things we're curious about here today.
All rise.
Hey, Judge McAfee's here.
Fulton County Atlanta Judicial Circuit is now in session. The Honorable Judge Scott McAfee is presiding. Go and now come to order.
Thank you all. Please be seated.
Right on time. Good morning, Judge. Nice to see you after your shameless position and order. So,
all right, we are back on the record with 23 SC 188947. Hearing today for argument on a couple of the still pending motions that remain. And so if I could first have counsel who are present here arguing today, starting with the state, identify themselves for the record and if their clients have waived their presence.
We got Fani?
Good morning, Your Honor. Donald Wakeford for the state. I'll be presenting with regard to any discussion the court wants to have on First Amendment issues. Joined today as well by John Floyd, Will Wooten, and Daisha Young.
All right, thank you.
Good morning, Your Honor. Steve Sadow and Jennifer Little for President Trump, and he waives his presence.
Pathetic. Fani didn't show up.
Craig Gillen, Anthony Lake for Dave Shafer, and Mr. Shafer waives his presence.
All right, thank you, Mr. Gillen. So we had a follow-up from our December hearing on focusing on the First Amendment grounds. As I took it, the focus of that was more kind of on maybe perhaps the procedural posture of how the analysis should be applied. But if you want to get back into the merits a little bit, you can feel free, Mr. Sadow. But the floor is yours.
Your Honor, may I remain seated and speak into the mic?
That's fine.
Thank you. I think the first thing the court has to
Trump's
address is whether or not a First Amendment constitutional as applied challenge is ripe for pretrial consideration. Being candid with the court, if the court says it's not ripe, then making the rest of the argument is probably not the right time. On the other hand, we have already argued under Hall, and there's been other cases cited, that as long as we agree to, for purposes of the motion, the facts, not other allegations, but the facts, it is right. So I almost pause it back to the court whether or not we're in that posture.
And we can do a little quick ping pong here if we need to, just so we know kind of what the guardrails are. So I take a closer look at Hall, and I think there's a follow-up case. I think it was Boyer, maybe Bayer, I forget what it was called. And certainly they're going right at it as an as-applied challenge. There's a little language there I wanted you all to kind of give me your take on, where I think the quote was, "It's well established that vagueness challenges to statutes which do not involve the First Amendment freedoms must be examined in the light of the facts at hand." And so if you take the inverse of that, it almost makes it sound like you should not be considering First Amendment challenges as applied. So I'm curious your take on that. But setting that aside, I mean, it certainly seems in other jurisdictions as applied First Amendment challenges happen all the time. And so it could just be that we haven't actually had the opportunity here in Georgia to address that on the merits.
Another first. Amazing.
But what also seemed clear, even reading Hall, is that if we're in making an as-applied challenge, we're within the confines of the indictment, because unlike Hall, the state hasn't said, here are some additional facts that we're willing to stipulate to or concede to or anything like that. Any and all of that, any reactions?
I understand how the court could look at the inverse, but I think as written, with all the justices agreeing that it is a First Amendment challenge, would be ripe, a constitutional challenge on the First Amendment grounds, as long as we accept all the well-pleaded factual allegations in the indictment and don't go beyond those. Now, as the court has indicated, the state at this point has not set forth or stipulated to any other facts, although I think some of them, for example, the fact of how a letter gets to the Secretary of State or the telephone call that is at issue, I think those things are clear throughout the record in this case. but I'm not sure that they're necessary for the court to make an as-applied challenge. And as such, I think we can be limited to the well-pleaded facts, both in the RICO count one, as well as the other counts in the indictment.
Well, let's just start there. Mr. Wakeford, any reactions kind of to some of those things I brought up and Mr. Sadow's response?
Will it annoy the court if I actually come?
You can stay wherever you'd like.
I think we got to start with Hall, Your Honor, and I'm glad you pointed to that language because that was going to be the first thing I wanted to address today.
This guy looks new.
Descends from a case called National Dairy, which the language in Hall says, in cases like this, we're confined, we look at the charge conduct. That's what we look to. And Hall, of course, they looked outside of the charging instrument to these other facts.
Yeah, so it seems like that's not going to be an issue here because the state's not saying, here's our entire theory of the case. So what stops us from doing an as-applied First Amendment challenge just based on the indictment itself? And that's a limited one, and you kind of have a leg up since you get to put whatever you want in the indictment generally.
Well, and that's kind of the thing, is that when you look at the post-hearing brief from the defendant, and you actually look at footnote 2, he's not actually asking the court to look at the well-pleading allegations in the indictment. He's actually asking the court to read out certain words, all of which have to do with intent. So footnote 2 on page 2, he says, if it says something's unlawfully or knowingly or willfully done, that's not a factual allegation the court should consider. So the suggestion seems to be, let's look to Hall. Hall says we can play kind of fast and loose with what the facts are. And in this case, what we want the court to do is read out certain language from the indictment, actually not consider it.
Okay,
Just look at
let's say we don't get to that further
Because
step
Trump has
and
First
we are
Amendment rights to speak.
just getting over that threshold.
So you
even
can't
if there was no
include it in the
footnote 2.
indictment.
Any position at this point on can we make an as-applied First Amendment analysis of this?
So it's true in federal courts. It's kind of all over the place. Some courts explicitly stay away from it, and other courts go into it. We know that in this defendant's case in D.C., actually Judge Chutkan explicitly went forward and made an analysis based on the allegations in the indictment there. But not every court does.
Case.
And some federal courts stay away from it for a very specific reason, which is that there are still factual allegations which have to be settled by a fact finder for a jury. And the reason...
And looking at all the cases that you found, ones that didn't do it, I know generally they're going to say, we don't have the record, we don't have the facts. But were there any that explicitly said, even though I could just look solely at the indictment, I'm still not going to do an as-applied challenge?
Well, I think that's how we get to a case here in Georgia, and it's a case Your Honor cited back in October when you explicitly ruled. We're not going to get into this.
That was the 11th Circuit case, though, wasn't it? You're talking about?
I'm talking about the major case, which is a Georgia case. The major case is where they say, okay, this is a pretrial, as applied First Amendment challenge, but essentially what this boils down to is an argument about intent. That's what the defendant's really talking about. And when you look at what the defendant wants to argue about here today, it's just saying, well, I was just a guy saying things. I was just advocating. I was just speaking my mind.
He has free speech.
And so all of this is protected, and therefore
Just like
the entire
everyone
thing
else.
has to go away.
I think that's
question.
your strongest argument on if we're in the analysis of the as-applied challenge. I'm still just trying to get over and really understand the procedural element of it.
Well, and that's what Major says, is that because that intent question has yet to be answered, and the jury is the person who is the entity that answers that question, it's premature to consider this. And you can't say that the First Amendment has been applied or that the as-applied challenge can succeed at this stage because there's still questions that have to be answered.
But Major, I think that was like an overbreadth on terroristic threats, right?
It begins with overbreadth, but then it moves into an as-applied challenge. That's the last part of the major.
And did they actually say premature, or did they just say denied?
They say that they cannot say that it's unconstitutional under the First Amendment as applied to the defendant in that scenario because there are still intent questions.
So does that actually maybe suggest then that they did do an as-applied challenge? It's just very hard for a defendant to win that because all you have is the indictment.
That is a way that you could interpret it. It would suggest that an as-applied challenge cannot succeed under the First Amendment because speech integral to criminal conduct is not protected. A well-pleaded indictment is going to demonstrate that speech that is pled as part of a criminal charge is integral to criminal conduct. And so there's nothing to decide if you're looking and you're cabined by the indictment. So we sort of have two routes here. Neither of them result in the grant of this motion. One says, the court says this is premature. There's questions that have to be answered. Any First Amendment challenge has to happen after there's a factual record to look to. And the other says, Okay, I can get to this today. It's not that I can't. I can, but there's nowhere to go because all of the speech is pled as integral to criminal conduct, and therefore it's not protected by the First Amendment.
You could envision an indictment. I don't remember if Alvarez was a post-trial or pre-trial thing, but you could envision an indictment where perhaps they've drafted it to solely target speech because of its falsity or something like that. So maybe there's a use for an as-applied challenge in that kind of a situation.
That's a fair point, Your Honor. It's just not the situation here. And it's
Sure.
not going to be the situation in almost any case. That was a special case where, of course, you have a very unique statute that was punishing. But that was really a facial challenge too, because it was saying like, this is just punishing falsity for falsity's own sake.
Yeah.
None of the charges in this case are about that. They are about falsity employed as part of, or statements employed as part of a pattern of criminal conduct in numerous ways. So there's nowhere to go. And so I think it requires dismissal or denial at this stage, because you either can't reach it because there's facts that have to be established, or the indictment establishes that none of this speech is protected by the First Amendment, and the inquiry immediately ends.
All right.
Okay.
All right. So back to you, Mr. Sadow. Let's move forward with the idea that we're making an as-applied challenge solely confined to the indictment. This isn't a facial challenge. You're not saying any of these statutes are on this face
Correct.
unconstitutional. And your argument is that this is core political speech.
Correct.
So some crimes can be achieved solely through speech, though. Terroristic threats,
Crime, certainly.
solicitation. Why is that not what's happening here, as alleged?
Well, I think it requires kind of a detailed analysis, so if I may.
Sure.
All right, so the first thing we have to decide
Let's
is
go,
whether
Steve.
or not, and we're talking about President Trump, we're not talking about the actions of others. We have to look and see whether or not that which has been alleged as facts is in fact core political speech, political discourse, protected speech at its zenith. I don't think there's any question that statements, comments, speech, expressive conduct that deals with campaigning or elections has always been found to be at the zenith of protected speech. What do we have here? We have election speech. So
It's highly protected.
one must determine immediately whether that constitutes core political speech, and I suggest that it does. Now, does that make a difference ultimately? Yes, because the more core speech, the more it is protected, the less the government should be involved in restricting it.
Or criminalizing
I don't
it.
think there's any real doubt about that. So then the question becomes, is the mere fact that the state here represents that it is false or fraudulent under the statutes, is that enough? Now, from what I just heard, I think the state's position would be yes. All we have to do is say it's false, it's integral to criminal conduct, it's fraud, and therefore it can't be unconstitutional as applied. I don't believe that that's what the law says. I think what the law really looks at is as to each individual application of a statute, whether or not the falsity in and of itself alone is sufficient. And I think the case law indicates that that's not so, particularly, and I don't need to go back through in detail everything that Alvarez said, but I think Alvarez is important because even when you talk in terms of, and I'll start with we're looking at the majority, I guess it would be the plurality opinion, that by Judge Kennedy, but for purposes of interest to us, the Chief Justice and Justice Sotomayor agree. So now we're talking about two people still on the court. And I'm looking specifically at page 723, in which the court goes on to say, were the court to hold that the interest in truthful discourse alone is sufficient to sustain a ban on speech, absent any evidence that the speech would be used to gain a material advantage, it would give government a broad censorial power unprecedented in this court's cases or in our constitutional tradition. So that's the beginning part of plurality, saying the way to attack false speech or false political speech or core speech is with truth, which is precisely what was going on. We're talking about this time period without getting outside the indictment. You're talking about at the same time the allegations are being made, factual allegations in the indictment, you have others that are fighting that off. The government's position would be with the state's position with truth. Moving beyond Alvarez, that part of it.
So it's only speech that has been criminalized.
You have Justice Kagan with Justice Breyer.
And we want
and here
more
I
than
think
that.
gets to the crux of where we are. And this is the concurring opinion. It goes through a litany of false statement cases in which the government's position in Alvarez is being false in and of itself is enough. That is, once you determine it's false, we're done.
Is it free speech or is
That's
it a
not what the
crime?
concurrent says, and that's not what the dissent says. The concurrent says, basically, that these judicial statements cannot be read to mean no protection at all. False factual statements can serve useful human objectives. For example, in social contexts where they may prevent embarrassment, in public contexts where they may stop or panic in the face of danger, and even in technical, philosophical, and scientific context where, as Socrates' method suggests, examination of a false statement, even if made deliberately to mislead, can promote a form of thought that ultimately helps realize the truth. And then it goes on and says, even a false statement may be deemed to make a valuable contribution to public debate since it brings about the clear perception and the livelier impression of truth produced by its collision with error.
Absolutely.
So this is
And you can
the
rule it out.
proposition that it's not the falsity alone that controls. It's the context in which the speech is made. And if it is deemed false, and for purposes of the indictment, we have to assume that it is false because that's what the facts have been alleged. That doesn't mean it's the end of the analysis.
Why do we not also have to assume, since it's an allegation, I think you say in your brief, that it's unlawful, willful, and knowingly false?
So, because at least our position, President Trump's position is those are not words of fact. Those are words of legal connotation. And that while they have meaning, that would allow, for example, let's go to Alvarez in the Stolen Valor Act. Just because they alleged that it was unlawful didn't mean it wins. That is, it doesn't mean that the government wins.
But that's because they decided that wasn't a crime at all. I mean, that was a facial challenge where they said this statute, even if you violated it, violates the First Amendment. You've said that the RICO statute, you can violate it and not, it's not a, right? So we put legal conclusions in indictments all the time. I think that's going to be part of Mr. Shafer's argument in just a minute. I mean, you said a moment ago, just because the state pleads it, you don't think that's enough in an as-applied challenge, and I'm trying to figure out
as
why.
to statements such as legal conclusions are unlawful and so forth. Now, if there had been, I guess if the allegations had been broader, maybe we wouldn't be at that crossroads, but those aren't facts. The facts, as I've outlined or we've outlined in our brief, you take the overt acts, you look at those overt acts, and then those the same time we then look at the substantive offenses or conspiracy offenses in the rest of the body of the indictment. Words like unlawful don't change that. At least that's our position. So now we're talking in terms, going back to Alvarez and the concurring opinion, you're talking in terms of falsity alone is not enough. There are situations, contexts which override just the falsity alone. And that's, again, the political discourse, the political speech. The more significant it is to certain issues, clearly being president of the United States at the time, dealing with elections and campaigning, calling into question whether what had occurred, at least in the election of 2020 for president, that's the height of political speech. And then you go even to the dissent, which I think is as important because now you have Alito and Thomas, again, members of the current court. And I go to that. What I believe starts at page 751. And it says, even where there is wide scholarly, and this is 752, even where there is a wide scholarly consensus concerning a particular matter, the truth is served by allowing that consensus to be challenged without fear of reprisal. Today's accepted wisdom sometimes turns out to be mistaken. And in these contexts, even a false statement may be deemed to make a valuable
Yes.
contribution to public debate, since it brings about the clear perception and livelier impression of truth
Yes.
produced by its collision with error.
Exactly.
Citing,
That's why the misinformation
US
people are
Supreme Court.
idiots. We
that's
want
the
all the
essence of
opinions
what we
out
have
there.
right here. That's the facts that have been alleged. Essentially, the state's position is because, as alleged, what President Trump said speech-wise or expressed either through his speech or conduct, which is still freedom of expression, because that's false in the eyes of the state, it's lost all protections of the First Amendment. And the concurring opinion and the dissenting opinion in Alvarez suggests just the opposite. If anything, under the circumstances, it needs more protection, not less protection. So keeping that in mind, let's move to not RICO, put RICO aside for a minute. Let's move instead to the conspiracy counts, which are counts 9, 11, 13, 15, 17, 19. Basically, what the state's position is on that, because it took this position previously in its filing on September 27, 2023, in response to that which was filed by Chesbro. And I'm aware, of course, of the court's order that dealt with Chesbro, and it didn't deal with the as applied. So I'm dealing.
Well, and more so in that one, as I go back and look at it, there was a much more kind of concerted effort to bring in facts outside of the indictment, right? And they started talking about, well, there was a transcript at the meeting, there was this, so it didn't really seem to be a true as applied challenge, right?
But as the court noted in its order, at that point, it didn't determine that it was ripe for a pretrial challenge. So I'm taking what Chesbro, what the state said as it applies now, because it says in that brief that it was both as to facial and as applied challenges. Essentially what it says is, as to those counts, 9, 11, 13, 15, 17, 19, as to 9, 11, and 17, the mere fact that it alleges a fraud is enough. That's what's on page 5 and page 6. Since each of those statutes prohibit conduct involving fraud, we don't go any further. And I'm suggesting that's wrong, that you must go further. You must look at the speech itself, the expressive conduct itself in connection with those specific statutes. That's what the as applied is. The fact that it's a fraudulent statute. Now you want to look and see why, under the circumstances here, the language speech of the president falls within that. And if you look at it in that sense, the mere fact that it's false is all that they have. There's not a finding that the speech itself, beyond the speech itself, is fraudulent. What the state wants to do is say, we have a goal. We have an objective here that we put forward. Steal the election in an unlawful fashion. I say change that for a second to legitimate concern about the validity of the election. If that was the way you focused on it, which is a way to do it as applied, even with the facts,
Then it's not criminal.
would what President Trump said on those counts be a protected speech? And the answer is it has to be.
Yes.
Because the only thing that makes it fraudulent is the state saying it's false.
Right.
Take every one of those and say, okay, it's not false. It's protected. The only reason it becomes unprotected, in the state's opinion, is because they call it false. And that's what Alvarez doesn't allow. In and of itself, it cannot be simply the content-based. It has to be contextual. And the contextual here is a political core value being addressed, elections and campaigning. And that holds true for all of those that deal with the conspiracy. And then you deal with counts 29 and 39, which is the false statements charges.
This is good stuff. It's like,
Now, it is clear that the Supreme Court would find that a statement made under 1001, 18 U.S.C. 1001, would constitute the appropriate, let's say, abridgment or non-protected conduct or speech. But Georgia statute's a little different here because we don't have a materiality element. It's the mere fact of falsity, which violates, according to Georgia law, counts 29 and 39. You don't have to do anything else but make a false statement, even if it is political discourse, even if it is in the heightened context that I've suggested. If it's false, it's a violation of the law. And I'm saying as applied to political speech, that can't be constitutional as applied. Remember, no materiality, simply the fact that it said it. So essentially, what the state's position on that would be, it didn't have to be sent to anyone of consequence in the state agency. It just had to be said. Indeed, if you look at, and the most probably best example is count 39, that's a letter written after the election in September of 2021 from President Trump to Secretary of State, in which it has, according to that, one statement. And that constitutes, according to the state, falsity, but it's clearly political speech. And it's clearly being related to the activities and the matters that of election and campaigning, even after the fact. It's still related just to that. So looking at 29 and 39, I think you have a situation in which the falsity alone is all they have as applied here to political speech. It is unconstitutional as applied under the First Amendment. And then finally, you have count 27.
Quick question on that. Had you, I hadn't located one. Had you found anyone ever attempted a facial challenge on 161020?
Yeah, in fact, I don't remember the name of the case, but it has been upheld, even though there was references to the fact that maybe materiality should be part of it.
That's got to be the
Haley.
Haley case. That's
Yeah,
right. That's right.
So,
Okay.
yes, facially, yes. But Haley, of course, didn't go to the extent of trying to
Sure.
determine as applied in a particular context. And it's, again, I don't to repeat what I just said, but here we're talking about the heightened value of core political speech. And then with 27, we're talking about the filing of a false document. Again, the only thing there that involves President Trump is an attestation on the complaint. Now, all it refers to in the indictment is complaint. But again, we're talking about the act, the falsity or the filing of false document is the falsity in the document itself. And I'm suggesting under the circumstances that and that alone wouldn't violate that statute as applied. So regardless of the facial challenges, the question becomes here, is the mere fact that the state says fraud or false statement enough to get by an as-applied challenge? And our suggestion is it is not. Now let's go to RICO.
good stuff from Steve.
And I think RICO is more difficult, to be honest with you, because we're talking about a much broader statute. At the same time, when you look at the allegations against President Trump, all of the allegations involved expressive conduct or speech. We have false statements alleged in overt acts, and again, all of which are political core value, political discourse. you have false statements in overt acts 1, 5, 7, 8, 17, 93, 97, 108, 113, 133, 135, and 157. Purely, the only allegations there are falsity. There's no allegation beyond the fact that those statements are made. And I'm suggesting that, again, heightened political speech has to be looked at differently. When it comes to tweets, which is, at least the way the state sets it forth, is also political speech. And here, certainly by the then President of the United States, you have tweets in 22, 26, 27, 32, 75, 100, 101, 106, 114, 128, 138, and 139. So the majority of the overt acts involve false statements or tweets, which are clearly political speech. How best to deal with that under the circumstances? To prosecute those under a broad RICO charge, supposedly with contesting an election by, I guess, illegitimate speech or expressive conduct? Or is the way that we are set up as a country is that the First Amendment plays through this by others, by those that are complaining that it's false, proving it's false, bringing forth the truth. That's the essence of what Alvarez has said. That's the essence of what a case called Brown versus Hartledge, which is cited in Alvarez. It's 456 U.S. 45 at 61, a 1982 decision. All of those speak in terms of when you're dealing with that speech, that political speech, you're best to deal with it through the pushing forth a counter view of truth, not prosecuting the speech maker or the person that is articulating his political views. Here we've done just the opposite.
Not court of law.
We have decided that because those views were unpopular and in state's opinion false, we must prosecute them to stop them from happening again.
And because they hate Trump,
which is,
he's a political enemy.
The essence of why it's unconstitutional as applied, because that's not what the law says. Finally, the rest of the overt acts, either telephone calls or meetings or requests, no false statements. They're just acts, expressive acts. And they're in there as well. Those are political acts. And for the court's benefit, because I know there's a lot of overt acts, those are 9, 14, 19, 28, 30, 31, 40, 42, 43, 44, 90, 95, 112.
Remember,
in the old indictment is
RICO is a conspiracy plus all the overt acts.
Two is now,
in
I think, is
furtherance of the
125.
conspiracy. That's what he's giving us.
130, 131, 140.
These are not overt
156.
acts. These are speech. These are moments of
There is
talking
nothing alleged
that's
factually
protected.
against President Trump that is not political speech.
It's all speech.
So what this court has to decide is
Called people, met
the
people,
state's
asked them to do
position that
things.
fraud or false statements under these circumstances, which I suggest really is alone, is that enough to get it by an as-applied challenge? Our position is it's not. Is there another way to look at this? They're going to argue at the same time that it's integral to criminal conduct. But it's the speech that's being punished. That is the criminal conduct.
Yeah, RICO's
If it's
not a crime, according to
criminal
AOC.
conduct, there would never be an indictment for the RICO against President
Dismiss
Trump
this, Your
or any
Honor.
of these other counts. Take out the political speech, no criminal charges. Political speech disagreed with, basis for all charges. I think that is the best way for me to sum up where our position is.
All right.
Good
Thank you,
stuff
Mr.
from
Sadow.
Steve Sadow.
All right, Mr. Wakeford or Mr. Floyd, if there are any points that you wanted to address or respond to. I mean, well, I'll start you off with this. It certainly seems that the primary case driving Mr. Sadow's argument would be Alvarez. And, you know, because that's a fractured kind of plurality opinion, I'm wondering if you have any thoughts on just how much that can drive this. And I know the state back in December was also citing Alvarez as the primary case. I wonder if that's even the best one
Well,
for your
New
arguments.
prosecutor
think-
Donald Wakeford, who is probably not sleeping with Fani.
to address the first, I think, elephant in this courtroom.
I'm not
is that
sleeping with Fani.
Judge Chotkin in DC has evaluated all of these arguments.
Who
under
cares?
Supreme
She's
Court
biased.
precedent already. So I would refer Your Honor to that court's analysis because I'm hardly
of
going
course.
to improve upon the findings of a federal
Maybe you
judge.
should reference
However,
anger on too.
speaking with specifically to Alvarez, it is a plurality opinion with several different opinions written by other justices. What they all agree on, though, is that Alvarez doesn't change the law that speech integral to criminal conduct is not protected under the First Amendment, and that that's not what Alvarez was about. It was about punishing falsity for its own sake. So the question is that what the state is doing here? And by fundamentally rewriting the indictment, the defendant is suggesting today that that is somehow what the state is doing, when actually what
Your
the state is
indictment is
saying
flawed.
is that
That's the
these
problem.
statements made by the defendant were all employed as part of criminal activity, various conspiracies, frauds, intentions with deceit, and violations of the law. It's not just that they were false. It's not that the defendant has been hauled into a courtroom because the prosecution doesn't like what he said. He is free to make statements and to file lawsuits and to make other legitimate protests. What he is not allowed to do is employ his speech and his expression and his statements as part of a criminal conspiracy to violate Georgia's RICO statute, to impersonate public officers.
What other acts
to
are you
file false
alleging?
documents,
That's not speech.
and to make false statements to the government. That's what he's alleged to do. He's not charged under 161020 because he told some lies. Although it is very interesting to hear counsel for Mr. Trump tell us about the usefulness of lies. He's not being prosecuted for lying. He's being prosecuted for lying to the government, an act which is illegal because it does harm to the government. That's the reason that it's illegal. That's why it's different from the statute evaluated in Alvarez. Same thing with filing a false document. It's not just that you've made a false statement. It's that you swore to it in a court document and submitted it to the court. That does harm to the judicial system. That's obviously different from just falsity being punished for its own sake. And that is what each and every charge in the indictment demonstrates, is that these statements are part of criminal conduct that is larger than just the false statement on its own. Especially with the RICO charge, where what we see is that this is a criminal organization whose members and associates engaged in various criminal activities, including but not limited to false statements and writings, impersonating a public officer, forgery, filing false documents, influencing witnesses, computer theft, computer trespass, and on and on and on. What the defendant is suggesting to Your Honor is trying to get around to the fact that because it's almost saying that because these statements are false, that these charges should be dismissed. It's like, well, you can't punish falsity on its own, and yet each time you look at the charge, the government's saying, the state is saying that he lied. So that must be the end of the inquiry. But that's not the end of the inquiry at all. That's not what the indictment says. It's not just that he lied over and over and over again, as counsel for the defendant points out by listing all of the instances in the indictment. It's that each of those was employed as part of criminal activity with criminal intentions. And we finally get to a place where
They're just jumping to that. They're
where I knew we
presuming
would
his
end
intent.
up, which is saying, I believe Your Honor was requested to
He
think
was
about it
legitimately
as not as
investigating an
lies,
election.
but as legitimate concern about election issues.
Yeah, like Trump did.
Well, that sounds like a trial argument to me. But this is why I began by talking about intent with Your Honor, because I knew we were going to end up in this exact place where he said, sure, you can look at them as lies because they weren't true, or you could think this is just well-intentioned concerns from an American citizen speaking his mind. And that, of course, would probably be a pretty good argument to put before a jury, and I expect we will see it, but it's not a basis for dismissing the indictment. The whole question of intent is
the indictment
no doubt
should have
going to
never
be
been
brought up. It
brought
can only be
against
determined by a
protected
jury.
speech. That's the
But
point.
what we have heard here today is an attempt to rewrite the indictment.
No,
To
you
take out the parts that are
incorrectly
inconvenient
wrote it
and
in the
only
first
say,
place.
well,
That's
it's
all they're
all
pointing
speech,
out.
it's all talking. And he was just a guy asking questions and not someone who was part of an overarching criminal conspiracy trying to overturn election results for an election he did not win by violating the RICO statute,
It
by
was
making
rigged.
false statements to the government,
Rigged.
by filing false documents, by impersonating officers, and doing a whole host of other activity which is harmful in addition to the falsity of the statements employed to make them happen. So I think there's been a suggestion that Your Honor can sort of reframe what you're looking at, but Alvarez does nothing to shift the basis that the court should stand upon when evaluating the indictment. And that is to say, is this speech being punished solely because it's false, solely because of its viewpoint?
Yes.
Or is it speech that's being demonstrated as integral to a pattern of criminal activity?
No, first one.
And finally, the fact that it speaks to political concerns or core political speech, and this is something that the court in D.C. Thoroughly addressed, does not change the fact that it can be employed as part of criminal conduct. The mere fact that you're talking about issues of public concern or core political speech, which may be completely fine and protected in most contexts, does not mean that you cannot be indicted if you use that kind of speech to pursue illegal activities. That's the whole nature of the question. So it's very circular, and I would direct Your Honor to page 6 to 7 of the post-hearing brief filed by Defendant Trump, which says, the speech integral to criminal conduct exception of the First Amendment does not apply here because all the charged conduct constitutes First Amendment protected speech. That is a very neat circle. The First Amendment protects us because all the speech is protected by the First Amendment. And in the end, no matter how much we hear about obviously the noble protections afforded by the First Amendment, all of this is an effort to get Your Honor not to look at the basic fact that this speech, this expression, all this activity is employed as part of a pattern of criminal conduct in a host of ways.
It was exposing
And because Your Honor is bound by the
conduct in
indictment,
the
it has to
government
look at the indictment
for
and can't look
producing a
beyond
rigged
it.
election
If
with
we're going to
water
get
main
into
breaks
this
at
at this
2 in the
stage,
morning in Fulton
then
County.
there's nowhere to go, as I said at the beginning, because this is all alleged as part of a pattern of criminal conduct and not protected by the First Amendment.
So you go through
Any argument to
somebody's
the
tweet
otherwise
history
is
and
just
just
to try to
gobble up
pretend
all
like
the
that's not
messages and say, oh, there's a conspiracy here.
All right. Thank you, Mr. Wakeford.
Thank you, Your Honor.
You just pick out.
May I add one point briefly?
Sure.
Thank you.
Wait a second, we're being doubled up on here?
It's not a trial. I think you can handle it, Mr. Sadow.
Whoa, Judge.
And this is, I'm just going to be on one specific point, not
Don't
duplicate
think
the argument
Fani's
made
sleeping with
before.
this guy either. I'm not sure though.
I
John
believe
Floyd.
Defendant Trump fundamentally misunderstands the role of an overt act in a conspiracy case. As we've discussed many times previously, this is a RICO conspiracy case. And so we heard Mr. Sadow discuss various overt acts and say, well, but this is just a tweet. This is just a phone call. This is just X. The unspoken underlying and incorrect premise then is that every overt act must be a crime. As we've discussed a number of times, and as the state has set forth extensively in multiple briefs, that's not true. The purpose of an overt act is to show that the conspiracy is in operation. It is not a separate crime. It doesn't have to satisfy the elements. It doesn't have to be pled with that level of detail. as Your
Fine,
Honor
but why
acknowledged
can you
in an order, I
criminalize
think,
something
that's
that's
all
not
of 2 weeks
criminal,
old.
which is free speech?
And so to say we can't mention this particular act or this particular conduct because it's not a crime or it's protected by the First Amendment, the answer to that is actually, so what? Because it could
you
be
can charge whatever you
it could
want?
be legal conduct. It could be First Amendment protected conduct. That also shows there's a conspiracy in operation. And that's, as long as it serves that purpose, it's fine.
It's
And
an
so
election- this is
overt
an
acts
election speech.
should not be examined by a standard that has no application to them. They are not separate freestanding offenses. And there is federal case law that, if need be, we can cite it to you, that has said an overt act can involve First Amendment activity. Its purpose is not to be something that is separately charged here, separately
Let's say
subject
it
to
can
a separate
involve, but
sentence.
not be the main
Its
point
purpose is
in
to
the
show that
overt
there
act.
is a conspiracy and it's an operation. Georgia RICO requires one overt act by any one defendant. So of course, the RICO would stand if anything, any of the 161 overt acts alleged constituted an overt act. It would only take one. It doesn't take any by Mr. Trump.
So they can just go find whatever they want, pull it out.
But the point is,
Overt act, overt
we
act,
have an
overt
abundance
act,
of
overt
them
act.
by Mr. Trump. And
All of his
for purposes
comments.
of the RICO statute and the manner in which it functions, it doesn't matter whether that's First Amendment conduct or not. I mean, my colleague has fully explained why much of this conduct is not shielded under any circumstance by the First Amendment, and I don't mean to contradict that in any respect. But it's important not to lose sight of the function the overt act plays, the role it plays in a conspiracy case here, because it is not the role being suggested by Defendant Trump.
All right. Thank you, Mr. Floyd. All right, Mr. Sadow, I'll give you a couple minutes. Final word.
Thank you, sir. If I heard what Mr. Floyd just said,
Trump's attorney, Steve Sadow.
that if everything President Trump said was assumed true and included in the RICO indictment, and therefore now we're talking about true political speech, not alleged false, he could still be prosecuted for the violation of RICO.
Could the overt acts as alleged, let's say even the overt acts ran afoul of the First Amendment? You're saying that wouldn't be fatal to count one?
Because at that point, if
There
the
could be some
over-
other thing they prove that's not alleged as an overt act,
Okay, that may
as I understand it.
as I understood it as well. But what I'm suggesting is, if all of the overt acts are nothing more than core political speech or expressive conduct, and nothing else is alleged which is not protected by the First Amendment, then you have an insufficient basis for which he has been indicted, because he's being indicted for First Amendment
Conduct.
speech and not for unprotected speech. And therefore, the statement that was made about if it were true, we could still use it as an overt act, suggests that they can prosecute true speech, which is what we're trying to get to
Right.
here.
They-
It's the
he's
nature
basically
of
said they
the
can.
speech, the political speech,
He just
the
said they could.
heightened value of such, which gets this situation different than others, and the fact that it comes from then President of the United States. Going back to what was said in addition by the state, what the state claims is criminal here is lying to the government. That's what it said. That's the exact reason why in several of the Supreme Court cases, it's been found to be protected speech because it deals with the government, and falsity in sense of communication with or to the government is best dealt with through true speech,
Right.
not through prosecutions, because prosecutions chill speech. And when it comes to political core speech, what you don't want is chilled.
Trump's
I
speech
use,
was the true speech. That's the problem.
Fortunately,
though.
I have a co-counsel.
Trump was right. They were
that's
wrong.
Able to pull things up and help me inform the court until the computer shuts down. And looking at what Haley says, just to give you an idea of how the Georgia court, the Supreme Court might look at this. There's a quote from Haley, and it says, "While there is no constitutional value in false statements of fact, such erroneous statements are nevertheless inevitable in free debate, and punishment of error runs the risk of inducing a cautious and restrictive exercise of the constitutionally guaranteed freedoms of speech and press. Accordingly, the First Amendment requires that we protect some falsehood in order to protect speech that matters." And I think that's what we're talking about here. To end this, and again, we're focusing on President Trump's conduct at the time that he, in fact, is the head of the executive branch.
As the president, executing the laws in
There
a
is
rigged election.
references to this in Brown v. Hartledge, and I cited that earlier. A well-publicized yet bogus complaint on election eve raises the concerns that you may have some impact that would affect an election. But the preferred First Amendment remedy of more speech, not enforced silence, has special force. Underlying our dependence upon more speech is the presupposition the right conclusions are more likely to be gathered out of a multitude of tongues than through any kind of authoritative selection. To many, this is and always will be folly, but we have staked upon it all. And for speech concerning public affairs is more than self-expression, it is the essence of self-government. And that comes from Garrison v. Louisiana, which is cited also in Alvarez. Bottom line here is this. But for protected First Amendment speech, President Trump would not be charged in RICO or the other counts.
Yep.
Take out the protected speech,
No
and you
case.
don't have an underlying basis for which to charge him. And since that violates the Constitution as applied to the charges here and his speech here and his position here, this is ripe for a constitutional challenge. One step further. If it's not ripe now and we get into intent, when does the court determine that? Do you determine that after we have a trial?
I think it'd be the directed verdict stage.
Well,
right?
but would it?
Given
That's a
with all-
sufficiency of evidence.
With all inferences, yeah, in favor of the state.
That's a whole question. I mean, do we go through the whole trial? God forbid there should be a conviction, and then we go back to trying to determine as applied? I'm suggesting the reason it's ripe now and the reason why we don't even get to a trial
We
is
don't need to do
because
it.
it's unconstitutional to force an accused, be it the President of the United States, former president, or anyone else, to stand trial on protected speech.
Right on, Steve.
And I think that's what Alvarez and the progeny previous to that and after say.
All right. Thank you, Mr. Sadow.
Good stuff.
All right. Mr. Gillen, do you need a minute before we dive in, or can we get started?
No, we're ready to go.
Okay. So just teeing this one up.
This is David Shafer's attorney.
I know there's a good bit of your
He had
motion that
Two demurs.
goes back into a lot of ground I think we covered at the December hearing.
Well,
Or, excuse me,
let me start off with some good news for the court.
I'm happy to hear it.
See the smile already on the court's
All right.
face.
Well, cautiously
Our general and specific demur, a great deal of that does go into the areas of RICO that the court has
Demurrers
not only
calling
ruled on,
the
but heard
indictment
other
invalid.
arguments.
well, haven't ruled on it yet, but it was just,
Well,
we
I
talked
think
about
there was a
continuity. We've
ruling
talked about.
in October, the
Sure.
17th ruling addresses some of the issues that were addressed. So I'm not going to replow that ground. That the court has heard, aware of the government's position. I know that probably ruined Mr. Floyd's day by not allowing him to get up and go back over his
A
RICO
demurrer saying the
expertise. I'm
indictment's
not going to do
invalid
that.
on its
What I'd
face.
like
It-
to
it
do
doesn't-
that
it's not
today
sufficient.
is to move forward to some areas that I do think needs to be, and the question really, when the court said, do we want to have oral arguments today or not? And then the question was, well, because on the RICO thing, I think I probably could have said, if it was just the RICO component, I would have said, fine, let's just do it on the papers.
You've got a lot of other counts.
There's
So
some
I-
other things that I wanted to talk about and have the court focus on as it relates to some of the other aspects of the demurrers, special and general demurrers.
Why the
And,
indictment is
and to
invalid.
focus on that in this way. Number one, I want to talk a little bit about some of the counts impersonating public officers. I want to talk about the forgery, the false statements.
They're not stating a
briefly and
claim,
talk
they've
about
given
that,
the
but also
facts.
to raise this issue with the court. Now, we argued that in our pleadings, but the defendant still filed additional motions on these very issues and did a lot of his arguments. We know that the court granted the stay for defendant Still because he's of the state legislature, and thus, had that not happened, Mr. Beaver would be here with me talking about these issues. I think that the Still pleading addressed a lot of the issues that were raised in the response by the state, and so with the forgiveness, hopefully, of my dear friend Mr. Beaver, I'm going to mention some of the things that they mentioned, but I would hope on behalf of defendants Still, the court may listen to what I say, but also prior to ruling on these particular issues might afford defendant Still the opportunity to have his own oral argument day so that he could more fully address these issues. And that's and I would appreciate that on his behalf.
All right.
When we talk, let's get on to it. We're talking about impersonating a public officer charge, and we talk about that. When we talked about that, we talked about whether or not,
This is
the
David
charge,
Shafer's lawyer.
Right?
impersonating a public officer charge, count 8. We say that's subject to dismissal. In that pertinent part, it says on October the 14th, on or about December 2022, unlawfully, falsely held themselves out as the duly elected and qualified presidential electors from the state of Georgia, public officers with the intent to plead. Now, what we did in our pleading is we said, well, that is defective because under the statute 2151, as public officer, there is no reference there to presidential electors as being public officers, and therefore that should carry the day for us. The state's response says, well,
It's not
not so
specific
fast,
enough.
Mr. Gillen. We've got cases here that talk about situations in which 2151 doesn't carry the day and
Well,
isn't
not even cases. I mean, the statute itself.
right.
I mean, you're pulling that from the ethics statute.
Exactly.
So I'm not really sure why I would even look at that. I mean,
So-
public
so-
officers all throughout the code, and it's just kind of one of those hanging kind of question marks, I suppose.
So what the state does, and I can see the court's point. I'm not going to argue that. What I am going to say is that what they say, they cite cases where there are individuals that are impersonating agents, police officers, peace officers, or agents for Metro Atlanta Human Trafficking Task Force. Okay, that falls into that category. Trafficking in the task force or a federal agent. Those are things that the state responds to. I think that in the still motion, it covers some of the concerns the court may have regarding this issue of public officer and why we think that we should prevail on this as well. Again, hoping Mr. Beaver has his day.
Well, do me the favor, actually, I've kind of put the still motions in a box and I haven't opened it yet. So make those arguments for me.
Well, I'm going to,
All right.
but not as articulately, I'm sure, as Tom could do it. But I'll give you the flavor. The flavor of it is that in the still motion, which we adopted as after it was filed, it talks about how other case law in Georgia, when it talks about, first of all, 1610-23 doesn't define public officer. So we start from that. So we've got that out there.
So you
Doesn't
can't
not defining
defend
the
if you
public
don't know
officer.
what it's charging.
Now, but the still pleading does say that the issue of who is and is not a public officer is addressed in other contexts in Georgia law, usually in the quo merito proceedings where somebody's trying to find out the legitimacy of somebody having or holding a particular office. And in that context, there are cases citing in the still pleading that address this very matter. They cite Brown v. Scott and as a case in which the Brown v. Scott case, whether or not an individual has designation or title given to him by law or exercises functions concerning the public assigned to him by the law, they cite Brown. That doesn't, the inquiry doesn't really end there. The Georgia Supreme Court has noted the term public officer involves the idea of tenure, duration, fees, emoluments, and powers, as well as that of duty. And so that's McDuffie v. Perkerson, and that has to do really with grand jurors. So when someone says, well, is a grand juror a public officer? And the court, breaks down an analysis talking about that, saying, not really, because grand jurors may only meet for a few days. They're not essentially, they're not there for some sort of duration or tenure. They don't take the same oath of office as prescribed for public officers, and they lack the element of tenure and duration which must exist to qualify as a public officer. Well,
So how would that apply again to like a purely fictional task force?
well, I mean, let's forget the purely fictional task force. It would, let's have it, that case law from our Supreme Court, how it applies to our case. And how it applies to our case is the presidential electors are not people who have lengthy tenure, duration, which it must exist. frankly, their job is to meet for one day.
No, and I
So
see
they're
your
not
framework there,
officers
but
as
if the
charged.
framework is actually in this, whereas the Metro Atlanta human trafficking, of course, it doesn't even exist.
Well, it doesn't,
We
but
can't
someone
even
is
do this
pretending to
analysis of
be,
tenure or fees
someone
or
is
do-
pretending to be an agent.
Maybe
And-
they're a part-time. I mean, it seems like if
Well,
you know what I mean?
we might agree to
Yeah.
disagree here, because I think that when someone says, well, here's my badge, I'm an agent of enforcement of the law for, and then names a particular entity that doesn't even exist. They're pretending to be a peace officer. They're pretending to be an agent for the government, which by the very nature of that job would have tenure, would have responsibilities,
Yeah.
would fall into the definition that the Supreme
What
Court has
is an
given
officer?
in Brown
Fani
v.
says
Scott and
someone's
McDuffie v. Pearson
impersonating an
as to what a
officer.
public officer should be.
An officer
And
under
so,
Georgia law
in
says
that
this, our
context,
client did not do
we
that.
have,
So this
you know,
cannot
we
be a
have,
crime.
and same thing, actually, it popped up again on the issue in Morris v. Peters, another case, Supreme Court case, dealing with whether or not someone is a public officer. That had to do with a quo warranto against the chairman of the Georgia Democratic Party and whether or not he would fall in as a public officer. Bottom lining it, like in that case, and which found that he was not, like grand jurors and public party officials, presidential electors are not public officials under Georgia law, especially for purposes of 161023. Their jobs, services are temporary, like the grand juries. Their position really only arises once every 4 years, is limited to a single meeting on a single day. So it lacks that element of tenure and duration which must exist. So it's kind of like back to the political case, Morris v. Peters case, which dealt with a state party political chairman nominated in accordance with the rules of their party. But just because the fact that they were nominated by the rules of their party doesn't make them a public official. And like grand jurors, presidential electors they're not receiving their salaries for their service. So all
Fani
of that,
just
Your
found
Honor,
some
tells
statute.
us,
They kind of
that-
impersonated somebody. But presidential
this
electors are not
particular,
officials under Georgia law. That's not what the
count,
statute's for.
is flawed for the very purpose of these electors cannot be under Georgia law public officers. And so we although we agree with the court's initial position regarding the limitation on the definition of public officer in our pleading, good old Tom Beaver and the Still pleading has come forward to rescue us on that point. And so if you look at what they did, and hopefully Tom will do a better job of articulating those points, in their pleading, they talk about specifically some other cases that get into either in Texas and I think Utah as well, that deal more specifically with this. But for the purposes of argument today, I think that we've sort of got the drift on what I think is happening on the impersonation of public officers. They're not public officers, and clearly under the direction we believe of our Supreme Court, they could not be so judged. Now, again, I'm not going to spend a whole lot of time up here with the court, but I do want to touch on a few of the other components of our pleading, the forgery counts. Now, we indicated in those counts 10 and 16 are sufficient to dismissal. Writing a check in a fictitious name or a manner that the writing is made or altered purports to have been made by another person. That's the definition of 1610. We have what we have here in this indictment is we have an assertion that a writing or other than a check in a manner that the writing is made purports to be made by authority of the duly elected and qualified presidential electors from the state of Georgia who did not give such authority. Now, that's what they allege. Let's break that down as to why, and the state's response to us saying they want to focus on the phrase under the authority. And what we have here is the concept of what is the authority. Who is this on October the 14th? Who was the duly, who's the duly elected and qualified presidential elector from the state of Georgia who did not give such authority on December the 14th, 2020? Now, the answer to that is that as a matter of law, simply as a matter of law, and we're going back, Your Honor, to some of the arguments we've made with the court earlier on the issue of supremacy clause, but worthy of at least highlighting some of those points to the court for the purpose of making our point here. And that is this, that, under the federal law as it existed in 2020, when the state of Georgia failed to comply with federal law about having an adjudication of any pending controversy or litigation, and as we know, in the public record in this courthouse was the pending and unresolved Trump and Shafer litigation on the election. Now, because that lawsuit was not adjudicated pursuant to federal law, then the state of Georgia lost its ability after Safe Harbor Day, lost its ability to then name who the electors should be. And as we discussed earlier, and I'll shorten the argument, but for the purpose of the record, I'll just make the following points. Once that happens, and it's very, very clear from federal law and from the language from Bush v. Gore, the state, any
Dissenting opinion in Bush v. Gore.
yeah, true. But as it points there, it's like, it's not, they see it as not even a serious issue, because the clear reading of the statute would say, if you don't get it done by Safe Harbor Day, then you have lost out. And once that happens, the power then shifts back to the Congress. So as of, by law, we think, not a factual issue, by law, on December the 14th, 2020, there were no duly elected and qualified presidential electors from the state of Georgia because of that failure. And
So understand your point, and I don't want to get too deep into it, but since we're in Demurrer world here, wouldn't your allegation of whether a lawsuit was filed, whether it was pending, none of that's in the indictment? Doesn't that transform this into a speaking demurrer?
well, we don't think so, and the reason why we don't is the last time I think we quoted the court that the court could take a notice of the pleadings within the court system, and I believe that what we articulated there, and I don't think we had an objection from the state. Could be wrong, but my recollection is we didn't. That we then worked from the framework of, yes, in this courthouse there was they filing a pleading that we're not going. This isn't a speaking demurrer. It's a part of the court record. Part of the court record says there was a lawsuit that was not adjudicated by Safe Harbor Day. So we don't have to go outside the indictment. It's not a speaking demurrer. And because of that, by applying the law, these forgery counts, 10 and 16, in our view, must go. Now, the other counts that I would like to, or the other matter I'd like to discuss is the false statement component. And on the false statement counts,
Is that
of
14?
12, 18, and 40, dealing with false statement. Now, here, the issue here dealing with a false statement, for example, is when they're asserting that there was a document that was sent within the jurisdiction of the Office of the Georgia Secretary of State and the Office of the Governor of Georgia, departments and agencies of the government. Now, we've got two arguments to that. Number one,
This is that they falsely held themselves
and
out
again,
as alternate
back to Haley.
electors.
Haley talks about this issue, and when Haley talks about it, the key thing is whether or not there was agency with the key phrase, with authority to act on it. Now, there are two flaws, the fatal flaws the state has as it relates to this issue
The indictment
concerning
is
Haley v.
invalid.
State and on the issue concerning the safe harbor. One, as we mentioned, at that time, there was nothing for the state of Georgia to act upon. They merely received the information. It was merely a sort of a
Placeholder.
ministerial act, if you would. But even more fatal to their argument is the second argument that I made a moment ago, which I won't repeat other than referencing it. The failure to act by safe harbor date renders any activity on behalf of the state of Georgia, be it the governor or the secretary of state, renders that gone. Because now
Waived.
it's all gone back up to Washington, to Congress to deal with that. And the government in the state can't now say, or at any time say, well, we're saying that the Democratic nominees or the Democratic representatives for the electors, they ultimately became the duly elected. You don't do that. You don't parachute back into what happened on December the 14th. The world as we know it on December the 14th, there were neither Democrat or Republicans that were duly elected under federal law. And so given that, we believe that the false statement counts should go. Thank you, Your Honor.
So when they signed the
All right.
document on the 14th, they weren't impersonating
Okay, any
anything.
thoughts
There
from the
wasn't anything to be
State
impersonating.
reaction. Mr. Wooten, this one's yours.
All right.
Yes, Judge.
Will Wooten's
Why
up.
don't we pick it up on that last point, because I know we've
Another
dived
government
into some of this,
prosecutor.
not so much the safe harbor aspect of it in that argument, but the idea that the governor's office and the secretary of state's office just didn't have jurisdiction. I know you've said that that's an issue of fact that needs to be proven, but isn't that also something that could be shown by as a matter of law potentially? And I know you
Judge,
don't agree it is, and so you can cover all that.
Sure. I don't agree that it's a matter of law. It is an issue of fact. And we've briefed this extensively and argued this before. We believe that even if it's not an issue of fact, even if the court were to consider it as a matter of law, we've given ample reasons why under statute, all of these entities have jurisdiction over many of the crimes that are alleged in the indictment, many of the topics all of the topics where we've alleged that some of these defendants have made false statements regarding. So I do maintain that I believe that it's an issue of fact for the jury to decide that we have to put up that evidence. We have to ask the GBI officers, what is your duty? What is your authority? What can you investigate? We have to ask the Secretary of State individuals while they're on the stand, what are your duties? What is your job? What do you do? Why are these things relevant? Why are these material to areas where you have jurisdiction to do something? What is your ability to act on these things? I think all of that has to come out at trial. And so as it relates to that argument, I think it's way premature. And anything that again, I always go back to the standard for what is a demurrer, right?
Right. But I'm saying just if there was a statute that explicitly, said that they didn't have jurisdiction. Remind me, what is it that you're saying just as a matter of law as a parent that provides the governor authority over this after the safe harbor date?
Judge, I don't have the indictment in front of me, so I'd need to know specifically what
That's fine.
statement we're. I think
you briefed
this
it.
is in regard to the
Sure.
The certificates or the paperwork where if an elector doesn't show up on election day or on December 14th, that the governor has to ratify a replacement of that person.
I think there were some documents that were delivered by Mr. Shafer and his co-conspirators to the governor's office, trying to get the governor to do that. That's provided by statute, that the governor's the one that has to ratify a replacement. So statutorily, he absolutely has the authority to act on that matter.
Talking about the
Okay.
interplay.
All right, sorry, but from the
the
top, I
electors
think
and
there
the
was a lot of
election.
time spent on definition of public officer and some of the allegations raised in Mr. Still's briefing, which I think his motion deadline should be coming up soon. So if he's requesting argument, we'd have him in.
Sure.
But if you want to make any initial reactions, have at it.
Well prepared, Judge.
All right.
First, I want to I've made this statement in the past as it relates to Mr. Shafer, and I'll make it again, which is we have to address an elephant in the room. The elephant in the room is that Mr. Shafer is in the 11th Circuit right
You
now,
slept with Fani?
demanding to be recognized as a federal officer. So what are we? I mean, are we saying that this position of elector is an officer or isn't? I think they need to make up their mind there. But as it relates to, well, I've actually got quite a bit of ground to cover, and I'll kind of take it as it was raised by Mr. Gillen. I want to start with, and again, as we pointed out in our response, we don't believe that the definition section in
I think
2153
he as much
applies.
conceded that. So
But Judge, if it did apply, I think it actually supports us. Because if you look at paragraph B, this is 215322B, it says public officer means every other elected state official not listed in subparagraph A. So it's a comprehensive definition of any elected state official. So we believe that that would absolutely cover it to the extent that it's persuasive, that it shows that presidential electors are public officers. That definition says any elected state official. So they are elected state officials. I want to hit briefly on the cases that were raised by Mr. Gillen as it relates to what Mr. Still put in his pleadings, prepared to address those. First, there was an intimation that 161023 only applies to police officers or peace officers. We know that that's not true because of a case called Kennedy versus Carlton. That's 294 Georgia 576, 2014 Georgia Supreme Court case where a conviction was upheld for someone impersonating a DFAX employee, clearly not a police officer, a peace officer of any kind. So we can dispense with that argument. As it relates to the cases that Mr. Gillen referenced, the definition of public officer in other contexts, all of those cases deal with the definition of public officer in the context of a petition for quo warranto. I believe there's 3 cases that are referenced in Mr. Still's pleading. We're filing our response to that tomorrow, but I can kind of take them in turn. Mr. Gillen referenced this list of qualifications in the McDuffie case, tenure, emoluments,
In
duties,
order to
et
be an
cetera.
officer.
That's not the holding of McDuffie. So the way that the McDuffie case is structured is the Georgia Supreme Court says no one's ever definitively said what a public officer is in the context of quo warranto.
well, look, if you're about to file a response and Mr. Beaver may be requesting oral argument, why don't we just save it for when I've had a chance to
Sure.
read these cases and we can be more productive.
Sure,
at
I
that
can
point.
skip those cases,
Yeah.
but I did want to hit a few points, Judge, as it relates to the statutes that establish that presidential electors are public officers. First of all, the actual office itself is created by law. So it's created by the United States Constitution, Article 2, Section 1, Clause 2, and it's also created by OCGA 21-2-10.
So they're defending
that
their
actually
indictment, they're
establishes that
defending
there
their
is
charges. We
an
charge them
office of presidential
appropriately.
elector in the
Remember,
state.
6 charges have already
They
been
have
dismissed
duties
on
that are
this.
established by law. Those are established both in the U.S. Constitution and the 12th Amendment, as well as at OCGA 21-2-11. By law, they're elected by the public, 21-2-10. And also there was a reference that they don't get a salary. That's actually not true. There's a compensation for presidential electors that is set forth by law at OCGA 21-2-13. Additionally, the election code itself refers to the office of presidential elector. It refers to it as an office. In 2 places in particular, 21-2-132A and 21-2-132E. And again, we again rely on those cases that Mr. Gillen discussed. Garrison versus the state, 276 Georgia App 243, 2005 case where someone was convicted for impersonating a federal agent, an unspecified federal agent, and that conviction was upheld by the Georgia Court of Appeals. Cert was denied by the Georgia Supreme Court. And then the Liberty case where they, of course,
So other examples of other officers that have counted as officers
that doesn't
where the charges
exist.
have
So
stuck.
we would argue to the court that the definition for 161023's purposes, that our appellate courts have applied a very liberal definition as a public officer. It doesn't even have to be a real public officer, doesn't have to be
Whatever,
a
just
state
charge whatever you
officer.
want.
Anything that purports to be, someone acting by authority of the government
Yeah.
is a public officer. And that's certainly what presidential electors do. Their positions created by law, their duties are established by law.
So again, the statute
All right,
is
so jumping down
valid
to
as
the
charged because they're alleging he
forgery
is
counts.
a presidential officer,
Again,
and
elephant in
alternate
the room.
elector is an officer,
1691, there's
and so the law applies
at least
to
5
that
ways
person.
that you can violate the forgery statute. The cases that Mr. Shafer, the case that Mr. Shafer relies on, Jackson versus the state, that's someone who is charged with forgery based on purporting a document
So this
purporting
is
to have
creating
been
the
made
alternate
by another
electors
person.
document.
We did not charge under that provision of 1691. We charged under the final provision, which is by authority of one who did not give such authority. Mr. Gillen says that we didn't object to looking at these, things in the record in other cases. Let me be clear for the record, we do object. That's the definition of going outside of the indictment. So we agree with the court that considering those things outside of the indictment absolutely transforms that into a speaking demurrer. It's void, it can't be granted. If you look at the counts, the forgery counts, they track exactly the forgery statute. Case law tells us that that's what's sufficient for a general demurrer. I don't know that there's anything else to say about those counts. As it relates to the false statements, again, addressed that at the very beginning, but I would point out that in Haley, where both the conviction was upheld and the indictment itself was approved of, the indictment said this on the false statements counts. It said that the defendant did knowingly and willfully make a false and fictitious statement and representation in a matter within the jurisdiction of the GBI, a governmental agency, by calling himself the Catch Me Killer and stating that he killed 16 people. It doesn't allege any of the things that Mr. Shafer says in his pleadings that have to be alleged. They don't have to be alleged. Like they've done in other motions, defendant here is trying to add elements to this offense that just don't exist, trying to add pleading requirements that don't exist. And Haley tells us the case itself directly quotes the indictment. That indictment alleges far less than what we allege in our indictment. And they said that the Georgia Supreme Court said that case is just fine. I don't think that Mr. Gillen addressed the filing false documents motion. I believe in the pleadings, they state that those counts are flawed because they fail to allege that the filing of the false documents didn't succeed. Again, that's not a requirement in an attempt charge. And they also say that the counts don't say who actually attempted to place documents in a mailbox. The way that we've charged the count, we've charged all of those defendants individually and as persons concerned in the commission of a crime. And so it'll be for the jury to determine if they have, if all the defendants are liable for what one of their co-conspirators did. With that, I'll take any questions that the court might have.
Thank you, Mr. Wooten.
Thank you.
Okay, so Mr. Gillen, your last motion we had for today.
I have like
Oh, sure.
60 seconds.
Sure, have at it.
The last motion has some overlap with the current
state-
issues.
Did not and cannot answer the direct question about a violation of the safe harbor rule, why that would allow that situation to give the governor or the Secretary of State any authority to do anything. That comes in under several of the arguments that we've made. I won't repeat it, but they simply, their argument is, let's put an agent up and ask the agent whether or not he had authority. No. By law, by federal law, they did not have the authority. It's not whether some GBI agent thinks that he can come in here and tell the jury, pay no attention to federal law, pay no attention to the dissenting opinion in Bush v. Gore, pay no attention to that. I'm a GBI agent. I say we can do it. That's wrong. They lose there because the law is very, very, very clear. And we can go back and we'll both the state and I know the Shafer team will go back to look at our argument that we made to the court. When my recollection could be wrong, I don't think so. We'll see. But my recollection was because the pleading was a part of the court system that we had a citation which permitted the court to take that into consideration as part of the record and thus not going outside of the record for speaking demurrer. I could be wrong, but we'll get that to you quickly because that and they latch onto that to say pay no attention to the reality of what happened in this courthouse in the court filings, which destroys their argument. And so with that, Your Honor, I'll sit down and then I'll go back and get my other folder.
All right. So Shafer had 2 filings in, and I thought he was bouncing around between kind of the 2 of them, but he's got 2. So we're looking at 2 of these. These are both demurrer motions,
So
which are saying that the
in
indictment
your
is invalid.
last motion here, I'm kind of as we were with the First Amendment issue, I think we need to figure out where we are procedurally. Federally, it sounds like, this would be a pretty common motion. It'd be a surplusage motion. Georgia, it's not quite as clear for us. So, excuse me. Let's start with just the authority to kind of take a scalpel to an indictment and cut out things we don't like.
Well, I mean, Your Honor, we talk about there are two components to this motion. One, there's the strike surplusage, and then there's a dismissal that we asked for, which is kind of also a component of the other. Now, we cite the state v. Corin on the issue of being able to, the allegation, the indictment is not wholly unnecessary to constitute an offense as mere surplusage. We think.
Right. But when we read the surplusage opinions, we're talking about, a miscited code section or a wrong date or something like that. So I don't know. I don't think that's what you're characterizing.
No. I guess this is where I'm.
It's more just a legal conclusion, right?
Let me, a legal conclusion, number one, but it's even more than that. It's this. When they continually, in their pleadings, in the indictment, in their pleadings, in their extrajudicial comments that they make, they have bombarded the defendants, the electors in this case, with the concept of, and the phrase of fake electors. Now that is not, that is a description, a conclusion, and a pejorative description.
So it's a legal conclusion you very much disagree with. It's the core of your defense.
I think it's not only a legal conclusion, but it's also something that should be stricken because it is just a pejorative statement. I'm not saying, I'm saying, I can call you something really nasty in an indictment, and it doesn't necessarily have to be a legal conclusion about your violation of a particular law. And so that's what we have here. And we have this permeating this case.
Well, I'm just trying to, again, based on what we've seen and is allowable in Georgia, let's just make it simpler. If in a murder indictment, someone's alleged to have acted with malice aforethought, that's a legal conclusion.
Well, that's right.
And it's something that the defendant may really have an issue with, but we don't strike it. We just go forward and we go to trial.
That's part of the law.
Different world, different cases, not the point that I'm trying to make.
Well, and that's a part of the
What
law.
I'm trying to make is,
Malice aforethought's part
you
of the
put
law.
in malice aforethought because you put that in there to
It's
define
essential
the
element, sure.
terms.
Yeah, it's an
What
element.
about this one? There's one I remember
Thank
when
you.
we talk about nicknames and aliases. And I remember there's one in Georgia from the 90s. They put in an alias of Stomper. And he
Stomper.
beat the defendant to death.
Well,
And the Supreme Court said, that's okay.
you know why? Because they probably proved that there was an alias of that guy called Stomper. That's different than
At trial.
At-
The state's saying we're going to prove that you're
Well,
an
I think,
unlawful elector. or
well,
fake,
no,
whatever
no,
they
no,
want to
no,
characterize it.
in this indictment, what they have done in the indictment, it's not necessary for, if they want to, and we think it should be stricken, we think the count should be dismissed. We know that based upon the case law that we've cited. But in closing arguments, Lord forbid we ever get to closing arguments, hope we don't. But if we did, and they stood up and they said, well, we think that they were fake, that we think the evidence shows that they were fake electors. That's one thing. That's argument. That's advocacy. There's no place for it in the indictment. And there's no place for it in what they have done, not only in the indictment, but in their pleadings and statements they've made outside to the media. What they have tried to do is they want to have ingrained in the minds of the community and of jurors a concept that if you were not a Democratic elector on December the 14th,
By default,
casting your vote
fake.
at some other part of the state capitol, then you are a fake elector. And that is a pejorative term, not necessary for the charges, and should be stricken. That's the point that we're trying to make. And as it relates to our other arguments concerning the dismissal of those counts, I don't think I need to go back over. Most of my argument, or our argument on that, really deals with the Electoral Count Act, so I don't think I need to revisit that in case the court
We'll get there.
really wants to hear that again. I don't think you do. But
There was a
absent
lot of
that, Your
overlap
Honor,
between the
we
two
think,
motions.
number one, that the count should be dismissed. The reasons articulated earlier and in our pleading. And number two, that even if the counts are dismissed, in addition to that, references throughout the indictment to fake electors should be stricken as well. Thank you, Your Honor.
All right. Thank you, Mr. Gillen.
Nicely done. I think a better analogy might be like if you called it a cold-blooded murderer.
Judge,
or,
I'll be brief.
homicide.
Nowhere in this indictment is the phrase fake elector. It does not exist. Literally not in the indictment. So I'm not really sure what we're talking about, removing something from the indictment that's not there. As the court pointed out, and I struggle with this motion, and I'm not going to say much because we're primarily relying on our response, but an indictment is itself a legal conclusion. Every allegation in an indictment is a legal conclusion. That's what an allegation is. And so if indictments aren't allowed to have legal conclusions, then I guess we aren't allowed to have indictments anymore. Judge, I think what the defense's strategy is here, and I know it's their strategy because they ask for it in the motion. They say, Judge, you should strike this language from these counts because we don't like it. It's not fair. It's pejorative, whatever reason. And now that you've stricken it, the counts don't charge a crime anymore. So you should dismiss them because they don't charge a crime anymore. That's nonsensical. We cite in our briefs opinions where the court says, the appellate court said, you literally can't do that. If something's essential to the charge, if it's essential to pleading an essential element of the charge, you can't strike it. It's not subject to being stricken. And I just highlight one citation that we reference in our brief, Malloy versus the state, 293 Georgia 350 2013 Supreme Court case. And that case says that when language in an indictment accurately describes the offenses charged and makes them easier to understand or more easily understood, they're not subject to being stricken because they're not surplusage. And that in making that in analyzing language in an indictment, in this context, Malloy also says that the language is to be interpreted liberally in favor of the state. And so with that, again, we rely on our pleadings. The phrase fake elector does not exist in this indictment. Take any questions that the court may have, but otherwise.
False
nothing
presidential
further.
elector does. So false presidential elector.
Maybe one. I've seen a line of cases talking about whether defects, can
it's not
be
fake, but it's
stricken,
false.
and a lot of that depended on whether they're material or
False
non-material.
electoral documents, false
Is it
electoral
safe to say
college,
that these
false electoral
phrases,
college.
the ones that are highlighted here, lawful elector votes, false electoral college votes, and duly elected and qualified presidential electors, would you say those are material phrases for each of the charges they appear in?
So I think that's a great question, and I think there's kind of a superficial answer and then maybe a more in-depth answer. My superficial answer is yes, they're material, in the sense that they make the charges more easily understood. They're accurate, describe the charges. I am familiar with that line of cases, and it's a little bit unclear in the cases whether material means that or whether material means that, if you strike something from the indictment that the count falls apart.
Sure.
So I'm not clear. What I know is in this context, I don't think it matters because what's being challenged, I think that it's approved of by our appellate decision.
If you've happened to go down that road though, and we take the position that material means it can still survive general demur. Any thoughts there?
Judge, again, turning back to Malloy, the holding in Malloy is that as long as the language in an indictment, even if it's not essential to an essential element, as long as it's accurate, it describes the offense's charge, and it makes it more easy to understood, it's simply not surplusage. If it's not surplusage, it's not subject to being stricken.
But do we think these phrases are material and meaning they're necessary to survive a general demur? I don't have them in front of me, so.
I don't either,
Okay.
and so I hesitate to give an answer without the indictment in front of me.
That's fine.
Again, as long as the charges track the statute, they survive a general demurrer. So anything that's not statutory language, I guess, wouldn't fall into that category. But then we get into special demurrer territory, and that's a whole different situation.
All right. Fair enough.
Thank you, Judge.
Okay.
All right. So that
thank
should
you
be
all.
it.
Anything else we should, or matters of housekeeping, anything else we need to take up before we break? Anything from the state?
Nothing from the state, Your Honor.
All right. Thank you, Ms. Young. Anything from either?
That was Dacia,
counsel?
not Fanny.
Okay.
No Fanny in the room.
Then we'll be adjourned. Thank you.
All right. All rise for
Judge.
Judge McAfee. All right. So that was the first hearing back since Fanny was saved by Judge Scott McAfee. She didn't show up in court. She sent some other attorneys in, and some new faces have made some appearances that we haven't seen in some time. And no Nathan Wade in the courtroom. Nathan Wade probably on a cruise again. I don't know. Probably, took all that money and ran $700,000. He's like, see ya. So long, suckers. Have fun with your Trump prosecution. And call me if you need any notes, because they're all up in here. So very interesting day, and a couple of those motions that we covered. Let me just run you through what they look like just to fill in some of the gaps here on what we were talking about. So obviously no ruling from the judge. The judge is going to take this all under advisement and then come back out and issue a ruling later on. But this is some of what we were talking about here. So this is what the filing looked like from Steve Sadow. Steve Sadow sent this one in, and you can see State of Georgia versus Trump. Just briefly to give us some background or to fill in some of the gaps, they say, as stated at the hearing previously, this is what came in before the hearing today. They say the First Amendment, this was Steve Sadow's argument, says that only though it protects Trump, right? And basically all of these counts against Trump can't be charged because the overt acts, every single alleged overt act. So, right, remember the indictment in the RICO case is a big series of overt acts, essentially. See all these different overt acts. These are not separate charges, not separate crimes, but they're saying there's a bunch of different stuff that happened, and each one of those can be added up into an overt act. And so basically what they're saying here in Trump's motion, which is to dismiss the indictment, essentially, it's a demurrer, saying that they're trying to criminalize those overt acts, but those overt acts are content-based core political speech and their expressive conduct, which is all protected by the First Amendment, saying the offenses that are alleged against Trump involve 5 distinct areas: the elector certificates that were sent to Congress, the request that was made of the Georgia speaker to call a special session, the verification attached to the lawsuit that was challenging the presidential election, the call to Raffensperger, and the letter to Raffensperger, right? Those are the different, ultimately, charges. Now, the RICO account says there's a broad conspiracy about all of those different conversations, saying it's unlawful. But Sadow said, wrong. Like every American, Trump has the First Amendment. It protects Trump's speech, just like it does for the rest of us. If there is any constant in our democratic system of government, or what's left of it, it is that the marketplace of ideas not the mandates of government functionaries or partisan prosecutors determines how we debate in America. And of course, think about this back during the pandemic. Like if we would have had good information, the whole thing could have changed a little bit. But unfortunately, people who had alternative solutions were censored. They had, hey, try this, try this, try. That's misinformation. That's disinformation, and so on. And so the lubricant of society, which is our speech, which helps us all get information, and bad information is good information, because oh, somebody's tried that. Somebody put that, somebody did that thing, and that's a bad idea. And we're watching them say other people should do it, and we're watching these bad consequences. And so we want to hear about that, right? Otherwise, we are kept in the dark. The founders sought to protect the right to engage in political speech, which includes free discussion of government affairs, including rigged elections. And the free speech clause embodies our national commitment to the free exchange of ideas, which it used to be, okay? We do not have a free speech country anymore. That's not a value that is something that a lot of people care about. I mean, a lot of people here care about it, but not a lot of our elected officials, and maybe even not a lot of our court justices. We'll see. The First Amendment offers its broadest protection and free speech regarding government affairs, but it encourages exactly the kind of behavior that's under attack here. We want people to ferret out corruption and problems in our government. Free marketplace of ideas is at the centerpiece of our country, but this indictment by Fani literally directly targets core protected speech and activity. And so it's categorically invalid under the First Amendment. They say no exception to the First Amendment applies here. This is Steve Sadow saying the speech integral to criminal conduct exception doesn't apply here, right? Because all of the charged conduct is protected. To fall within the exception about criminal speech, right? Criminal speech is not protected if it's integral to the conduct. Then the speech, it must be integral to some criminal conduct. But the conduct that is alleged here that's a crime is protected speech in and of itself. So it must be integral, protected speech that is integral to other protected speech and other protected activities remains protected. And they give us some cases that Steve Sadow walked us through. But in Fulton, the Fani prosecutors have not identified any non-speech or non-advocacy conduct in the allegations against Trump. An examination of the indictment reveals why. Just look at it. None of the allegations relate to any non-speech or non-advocacy conduct. Every charge, every single overt act that's alleged against Trump rests on core acts of political speech and advocacy that the First Amendment protects. And likewise, all the factual allegations in the indictment pivot on the indictment's core faulty theory that Trump supposedly engaged in fraud, false obstruction by repeatedly saying the election was rigged. And Fulton County prosecutors are wrong. They're concluding that claims of fraud are not protected speech. Sure as heck is. Trump's claims of fraud constitute free speech. The Supreme Court has talked a lot about this. Alvarez produced multiple opinions, but 9 justices were unanimous. Under the First Amendment, the government may not prohibit or criminalize speech on disputed social, political, or historical issues simply because the government says some is true and some is false. Justice Kennedy held that counter speech was sufficient because only a weak, pathetic society and weak, pathetic people who make up that society needs government protection or intervention before it pursues its resolve to preserve truth. Shout out to Judge Kennedy on that one. Only a weak, pathetic society run by weak and pathetic people need government protection. Nothing is truer than that. Pathetic. Censor them. They're posting illegal information, misinformation. Save me. Weak, pathetic. Government, put me in bubble wrap so I don't hurt myself. Grow up. Truth needs neither handcuffs nor a badge for its vindication. The fact that the prosecution alleges that the speech was false does not change the conclusion. Alito said the same thing in the dissent. The opinion least protective of speech affirmed even this principle, said it's of a grave and unacceptable danger to suppress truthful speech. and even non-truthful speech, because who could be the arbiter of what's true or not? Who knows? Any attempt by the Fulton prosecutors to distinguish this must fail. The indictment does not, and the prosecution cannot identify any non-speech or non-advocacy conduct by Trump. This convincingly demonstrates that the prosecution of Trump is political, and it's for political speech, and the conduct that the prosecution alleges is false, and they can't just do that. The Supreme Court case supports our argument. Any argument that falsity is not a viewpoint doesn't make any sense. The prosecutor's position here disputes the outcome of 2020, and a law that criminalizes people who have a different opinion is blatantly unconstitutional viewpoint discrimination. Criminalizing Trump's speech and advocacy, disputing the outcome, while speech endorsing the election's outcome is viewed as unimpeachable. It's blatant viewpoint discrimination. Trump says it was rigged. You say it wasn't. You charge him with a crime for that. That's your opinion that's different than his. Now, the expansive interpretation of criminal law as the First Amendment applies to it shows that the court cannot rely on the government's discretion to protect these types of prosecutions. And so thus, a statute in this field can be linguistically interpreted. If it could be interpreted to be a meat axe or a scalpel, use it as the latter. And so in conclusion, Steve Sadow says, the core political speech and expressive conduct alleged in this indictment against Trump are protected from government regulation and thus criminal prosecution. And that fact becomes even more clear when considering the context here. Trump was challenging a rigged election, political speech that was directed at state legislatures, state officials, all tasked with investigating the election, and other lawsuits against officials who were doing the same. The speech sought action by the government, which is the very body responsible for doing the governing. It was directed at bodies responsible for conducting government business, the bodies with the information in their possession, the bodies undertaking the investigation. The speech was directed at the government that the founders believed should always be challenged, and the bodies that must be capable of being challenged in a democracy where citizens are capable of guarding against oppression. Now, as applied here, the prosecution seeks to use statutes to charge Trump that were never intended to criminalize speech. Look at these cases. The statute was not sufficiently tailored, and it was meant to annoy him, and so the court held that it was invalid. Same principle remains here. The speech and the expressive conduct took place in the coveted halls that the founders created for citizens to resolve these complaints. Trump was talking to the courts, to the legislatures, to the state officials, and so regulating his speech usurps the First Amendment, saying the First Amendment prohibits the state from weaponizing its powers to silence disfavored viewpoints like the election was rigged and to prevent people from advocating those viewpoints. This is the ordinary course in a free society. And so this court should hold that the First Amendment's guarantee of free speech when applied to the core political speech and the expressive conduct in this indictment demands a pretrial remedy. And you know what that remedy is, says Steve Sadow? Dismiss this indictment. From Steve Sadow and Jennifer Little, which may have been seated next to him in the courtroom today. So shout out to Steve Sadow and Jennifer Little for explaining how the First Amendment protects against this weaponized prosecution. And it has a rhyme, it sort of rhymes with the presidential immunity claim, right? It's almost immunity via the First Amendment. Trump has the immunity to execute the laws. If the election is rigged, he's got the authority, in fact, the moral obligation, the sworn duty to go in and to investigate it. And that's all he's done. And they're prosecuting him for that because they don't want him to win. So that was from Steve Sadow. Now, David Shafer also sent in a couple of motions, quick highlights on these, and then we're going to hear from you. But two of them with a lot of overlap between the two. He said David Shafer files this special demurrer and a motion to strike these legal conclusions. And I actually broke this down a little bit on our mind map. And let me share this with you just so we have an understanding of what we're talking about here. It's kind of a confusing part of the law, but when we talk about demurrers, we're saying that the indictment itself is insufficient, okay? It's just not valid because it hasn't been written appropriately. So the defense doesn't have proper notice and won't have due process to prepare and defend against the case. So we heard today about a general demurrer and a special demurrer. two different concepts. One you might say is legally insufficient. Okay, so even if everything that they wrote in the indictment is true, there's no crime, right? There's no crime charged under the statutes. So you could have a situation where they say, yeah, you did this and you did this and you did this and you did this, but they don't actually lay out the elements of the offense, or they lay out the elements of another offense that they think applies to you and it doesn't. So even if it's true, like you're not defending against the underlying claims, you just say, well, you haven't alleged a crime there, which is some of what we saw there. They're saying, well, you said that he was impersonating an officer. He did all of these things, but he wasn't an officer. So the law doesn't match the allegations, right? It's legally insufficient. The law doesn't get you to a crime. We also have a special demurrer, which they'll say is a factually insufficient component in the indictment. So for example, they might say, well, you did a bad thing one time. You committed a crime one day. You know, what day? Between January 1st and December 31st, you committed a crime. What? Well, that doesn't give me enough specificity to prepare a defense. Like if I have an alibi, I can't tell you where I was on every single one of those days. So how about you give me some specificity, right? It's factually insufficient. We don't know the who, the when, the how. You said I did something that was illegal, but you don't say what I did. So I can't prepare a defense for that. So David Shafer submitted two different filings that are on this pretext saying that basically Fani alleged a bunch of stuff, but doesn't mean I did anything illegal. Shafer disputes the allegations and says this stuff should be stricken. So Shafer writes, the state has brought criminal charges against Shafer and others for meeting and voting as electors and sending a certificate in. And they repeatedly refer to, quote, Trump presidential elector nominees, makes allegations about a scheme and so on. But the indictment also repeatedly and improperly charges that the Democratic Party of Georgia's electors were valid, right? They say Georgia was valid, the Democrats were valid, and they say that the Republicans were false. They say that's ridiculous. At the time of the conduct charged in the indictment, Georgia law says that candidates may qualify if they follow the rules. So they're saying even if, right, it's like a general demurrer, even if everything you say is true, it's not a violation of the law. We're allowed to qualify this stuff. The Constitution says that electors can meet and they transmit the list to Congress. Now, during the time of this conduct, the Electoral Count Act stated if a state has provided for a final determination, then it shall be conclusive. Bush versus Gore was also brought up, which we heard during oral arguments. Now, the indictment says that Georgia's people, the Democrats, were duly elected and everyone else was invalid. But this is unproven, saying that's a legal conclusion. Mr. Shafer was nominated by the Republican Party and as an elector entirely consistent with state law. So there was no crime there, right? It's insufficient. The Electoral Count Act further doesn't prohibit Shafer and the Republicans from meeting and casting their votes. The state possesses no legal ground whatsoever to charge in its indictment that the Democrats were duly qualified. They don't make that basis. The vice president does. The prosecution's references, as alleged, should be stricken. They were not duly qualified. The indictment also says that David Shafer was a false electoral college person. These conclusions are erroneous and need to be stricken. The inclusion of this is going to confuse the jurors. It's a conclusory statement. Mr. Shafer and the other Republican electors were legitimate electors whose votes would be accepted by Congress, could be accepted as lawful electoral votes. And so they are erroneously saying differently. And also, they're not even public officers. So if you're saying that we're trying to impersonate a public officer, your public officer doesn't apply to the facts of our case. So it's insufficient. The prosecution cannot prove by evidence beyond a reasonable doubt that there were any writings that were altered, that were altering the Democratic alternate electors, okay? They wrote Republican elector, not votes, But the Democrat electors, they wrote theirs, and we didn't manipulate theirs, okay? So we didn't fraudulently modify their documents. And so Mr. Shafer is entitled to a proper indictment. He's entitled to an indictment without improper and prejudicial conclusory allegations, and the striking from the indictment the identity is also deficient. And so based upon the facts, we move to strike all of this from the indictment and dismiss these counts as to defendant David Shafer, counts 8, 9, 8, 10, and 16, signed by Craig Gillen and Holly Pearson. Shout out to them. Shafer's other filing, again, general and special demurrers, saying, moreover, they allege that Shafer made phone calls or sent emails or texts. None of that conduct is the basis for any substantive charge. They say that on December 14th, Shafer encouraged persons, to sign a document entitled Certificate of the Votes of Electors from Georgia. The state seeks to punish this conduct, but that conduct was lawful at the time. In nearly all of the charged conduct, Shafer was only attempting to comply with the advice of counsel and the requirements under the law. In fact, he was following the precedent of 1960 Hawaii, which is what we talked about. Remember, the United States Supreme Court observed this in 1960. They said in Hawaii appointed 2 slates of electors, and Congress chose which one to appoint. Alternate slates of electors, 2 slates, and the Democrats did it. Republican electors were certified by the acting governor. A recount was ordered on December 13th. Both Democrat and Republican electors met on the appointed day. On January 4th, the newly elected governor certified the Democrat electors. It's like a placeholder, which we've talked about many times. The certification was received by Congress, and they were then counted. So Republicans thought they had the win in the bag. They didn't. The Democrats lodged their alternate electors. We came back and sat them. The Supreme Court also held that peaceable assembly for lawful discussion cannot be made a crime, and to those who assist in the conduct of such meetings cannot be branded as criminals. And so David Shafer's challenges to the charges against him are on the grounds that a lack of notice that his conduct violates the statutes, and so he thinks this indictment should be quashed. Now, if the indictment is considered on its face, the indictment is problematic because it's missing important elements. Now, based on the fatal defects in the indictment, the charges are subject to dismissal and to demurrer. Shafer is entitled to an indictment in perfect form. He needs to know what it says. And here, we don't. The indictment is insufficient. We must know what it actually charges. The purpose of the indictment is to allow the defense to, prepare a defense, but this indictment is messed up. Count 1 charges that he was associated with an enterprise and blah, blah, blah. Now, it alleges that they were involved in a conspiracy, and it provides that it's unlawful for a person to be involved in the conspiracy. Now, this requirement is codified in the law, but if you view any of the allegations in Count 1 in a manner most favorable to the state, this is defective as it relates to Shafer, because there is no pattern of alleged racketeering activity. Here are the acts. They say this is all Shafer did, Fani. He didn't do anything illegal. Here's one act. He received or sent emails to co-conspirators. He got a telephone call. He sent text messages. He got a room at the Georgia State Capitol. He encouraged individuals to sign the certificate. He signed the certificate himself. He instructed another person to deliver the document, and then Shafer allegedly made certain statements. Now, neither these texts or emails, nor the reservation of the room, none of that constitutes racketeering activity. None of the conduct constitutes any offense under Georgia law. The prosecution is furthermore not even charged any of these emails or texts that were received by Shafer as alleged offenses. So setting aside all of this, during his voluntary interviews with Fulton County, all the alleged criminal conduct that was attributed to Shafer would have occurred on a single date, back on December 14th. And so this indictment alleges and fails to allege the elements, right? There is no pattern. There is no continuity. It's just one day. Failure by them to show a pattern means they fail an essential element. this all happened on essentially one day. And so count 8 should fail because he was not impersonating a public officer. What is a public officer? You know, governor, lieutenant, it's codified here under Georgia law. Very specific. Every elected municipal official and so on. An elector doesn't meet that standard. They're not public officers. Impersonating an officer is fatally defective because it isn't a public officer. It's for somebody who impersonates one of these people. Each member of the General Assembly, every elected county official, board of local education, elected municipal people, head of departments or agencies. It doesn't say presidential electors in here, governor, lieutenant governor, so on. So it should go. Now, as to forgery charges, the forgery laws in Georgia say what they are accordingly. But here, there's no allegations that Shafer forged anything. The prosecution has furthermore knowingly omitted from its indictment the fact that Shafer used his actual name, okay? It wasn't fraudulent it was his name. And he was doing it under authority from the state that says he can. So continuing, they say that count needs to go away. And criminal attempt to submit a false document charge is also ridiculous, saying the law says it is defined here, but count 14 suffers from a fatal defect. It alleges that Shafer attempted to send a certificate, but the count fails to specify to which person allegedly sent the certificate. So who sent it? You said it is an attempt to transmit a document. Send a certificate. Somebody sent it, but we don't know who sent it. And so because it's missing details about the essential element of the crime, we can't properly defend ourselves. This is a violation of our due process, and this case needs to be dismissed. And so based on this, dismiss the indictment and dismiss these counts against David Shafer, signed by Craig Gillen, brought into Judge McAfee's so-called courtroom. And so big motions that have been dropped, and we'll see what Scott McAfee does there, whether he'll dismiss any more charges. Remember that some charges have already been dismissed in another special demurrer because of some specificity problems. And so we're going to be here covering to see what continues on in this case, my friends, because we're going to wait for Judge McAfee to come out and issue a ruling. Are more charges going to be dismissed, or is Judge McAfee going to continue to support Fani Willis and her government prosecutors in everything that they do and allow them to continue on with this clearly unconstitutional indictment that violates people's rights to have due process, to have notice under the law, and to be able to exercise their free speech under the law? Steve Sadow showed up today, made good arguments in support of that filing. So did Craig Gillen on behalf of David Shafer. And of course, we're going to be here continuing to cover this case, my friends. So wherever it is you're watching us, my friends, thank you for liking this video. Thank you for subscribing to our channel. Thanks for inviting a friend or family member to come over here and join us, because we live stream 5 days a week, 6 days a week for our membos. And we'd love to have you and your friends here joining us as we cover all of this. We got some great links down in the description below. Watchingthewatchers.locals.com is where we do member-only streams in the morning and streams on Saturday. We have an amazing community there as well. Also want to invite you to check out robertgovea.com if you want to grab any PDFs that we cover here. You can download those online at robertgovea.com. And you can grab a brand new shirt or some gear by shopping on our YouTube channel. Now we have the shopping tab. And so if you like polo shirts, I link some of the polos that I wear on our shopping tab. You can go to Nordstrom's, click my link, go over to Nordstrom's. They've got some great deals. Load up your cart. They've got a lot more than just polos, tons of other stuff over there as well. And you can support the channel by grabbing some new gear and looking amazing while you do it. So we're going to be here covering this and more, my friends. Thank you for subscribing. We'll see you back here on the next one. All right, my friends. Well, that is it for us on the day. Early morning stream today as we cover this very spicy case moving forward. Let us see what you guys have to say about this. Of course, we are going to go over to watchingthewatchers.locals.com for our members only after party. And we're planning on a members stream later on the day. So we're not going to be back here for our show at a regular time. is what we're planning on. We're going to be doing a members only stream later on in the day. Hope to see you there. watchingthewatchers.locals.com. Now, my friends, thank you for sending in these donos and these questions and your amazing support on this beautiful morning. Let's see who is here starting us off on the beautiful day. What's up? We got R. Taylor. What's up? Richard T. in the house. Richard T. is coming in. We got some serious new supporters here. What's up, Richard T.? Jeff Lewis is coming in. SF is coming in. Welcome aboard. Renee is a new supporter. Welcome, Renee. And Charlene R. is coming in as a new supporter. And K. Bean is out there clipping for us today. Thank you very much, K. Bean, for helping out. We got Voice of the People is here. Says, early morning for Rob, huh? Tell me about it. I'm here for this. Working out of town, pulling fiber at a chicken plant in Mississippi. Wow. Too many people here don't know about this. Have at least 10 people from my job site tuning into this today. Woo! Voice of the People. Shout out to our friends in Mississippi. Pulling fiber at a chicken plant. Voice of the People and the Voice of the People crew out there. Pulling fiber. You know, I used to pull lights in swimming pools. That was the only thing I used to pull. So, you know, in a swimming pool light, you go to the J box, you tie on a line to the light. Then the pool, you just pull the pool wire out, zip in the, your fish tape through, and then rewire the back thing, the whole thing through, and the pool light will generally float. That was years ago. I don't know if the technology's changed, but that's the extent of pulling anything through tubes other than inner tubes that I've got here, Voice. But thanks for bringing your crew over to watch the show. Hopefully you guys are having a beautiful day out there in the great state of Mississippi. We got the Midwest Express says, good morning, Rob. Love the early morning live. Good to see you, the Midwest Express. Very, very nice to have you here on the early morning. And thanks for being a membo and for joining us. We got Daxinth is here, been a membo for 14 months. Amazing. Daxinth P, 14 months. That's 12 months and plus 2 equals 14, pretty sure. Says smash that like button. Thanks for saying that, Daxine. Thanks for being here. Dolphin Fan is the man, as usual, bringing in 10 new membos, including Jim H, Mr. Null, Axeman R, Debbie W, Joanne K, The Real Kittler, Beautifully Inappropriate, Craig V, Mainers in the house, Golden G, Marius B, and Dyer G in the house, all courtesy of Dolphin Fan is the man in the house. Michael Swade is on Rumble. What's up? Shout out to our friends on Rumble. Says, McAfee just discovered that Georgia didn't scan 148,000 ballot envelopes, so he knows the election was fraudulent. I wonder how will it affect the Trump case now that he knows that. Yeah, we played that clip. Harrison Floyd played that clip. And I don't know that I feel like the writing's on the wall at this point, okay? Like the judge has intimated where this is going. Like we know where it's going. We got What's Up Fran B. What's Up Fran says, astounding that we have to explain to a judge what free speech is. This country has fallen far from justice. Yeah, and isn't it a whole different vibe to listen to Judge McAfee now, after we know what he did to twist himself into a pretzel to save Fani Willis at all costs? Yeah, it's kind of gross, isn't it? Knox is here, defense attorney in Texas. Oh, hey, what's up? Okay, so my friends, if you're out there listening and you're a private investigator or someone who consults on criminal cases, you're about to be called to attention. Knox Bierman says, good morning, all. I love these early streams. Feels like a before work breakfast club. It is early. It is early. It's kind of interesting to get a jump on the day and hang out with everybody. It is fun. I kind of like it too. What's up? Okay, so here is a message from Knox. Knox Bierman, and this is serious. We talked about this yesterday in our members only stream. And this is a serious public, announcement. So if you happen to know anybody, this is like an ad. Defense attorneys seeking investigator. Knox Bierman, defense attorney in Texas, says, okay, so here's my shout out for investigators. You do not have to be in Texas. Scene recreation can be done via Google Earth, and witness interviews can be via phone. High-level felony trial prep all summer long. She needs assistance. First case up is ag assault with the S word in there. My guy is on video trying to throw a woman off a balcony while naked. Going to be a fun one. Great stuff. Stories you can't not make up. Email me at libralawtexas@gmail.com. All right. So I know consultants in Arizona, but I don't know anybody in Texas or anybody who would be willing to work in Texas. So if that is you, if you're out there listening, if you know somebody, if you're a defense attorney who knows somebody, Knox needs some consultant help, some expert witness help, send her an email. Knox says, okay, getting ready for court, but sounds like there's a new lawyer for the state. This guy can actually form a sentence. Yeah, they actually brought some competent people out today. We got Knox says, leaving for my own private Idaho, but a final thought. It all speaks to intent. You cannot impute intent of another. They would love to. They would love to try their Knox. They just say that Trump knew that it was lawful, but it was rigged nonetheless because they said it was lawful. And there's no evidence to support that. Voice of the people, bringing in 10 new membos. We got Mark S. is here, CF Martin's here, JDL, Andy B, Dixie Dogs, Carol T, Ewok Village Farm, Land That I Love, Johnny Commodi's joining us, and JP is in the house, courtesy of Voice of the People. And Voice of the People is the man. We got Glocky McGlock here says, this is the playbook talking about after the tougher on crime candidate led by 10,000 votes, 10,000 mail-in ballots were found due to human error. Now the race is separated by 1%. What a shock, right? Get used to a lot more of that. Repo Man says, love your show. Love the way that you explain what these people are doing in the name of justice. Thank you, Repo Man. I love you being a member. Thank you for watching. Thanks for being here. Thanks for supporting us. And shout out to your 3 American flags. Love them. We got TW1G says, what would happen if a lawyer argued that RICO wasn't a crime and cited AOC? It'd probably be hilarious. Maybe we should submit an amicus brief to dismiss the Georgia Big Fani RICO case because RICO's not a crime. One sentence, AOC's quote. Boom. Here you go, Judge. Case closed. Sandy says, I'm listening to this First Amendment argument from both sides and I'm wondering, what if Trump was just simply wrong? I don't think he is. The state's position is that he would still be prosecuted like this. Yeah, I think so. I mean, yeah, like if it was just an innocent mistake rather than like a malicious overthrow, right? Trump was just wrong. He wasn't rigged. They say he was malicious. He knew it was lawful and he claimed it was rigged. And I don't think that they can prove either one of those because, in fact, Trump was right. Dark Side Digital is here. Says this rogue prosecutor was making the case that Fani should be disqualified because she lied to the government, right? Yeah. Fani should be prosecuted for impersonating a prosecutor who's supposed to have some honor and integrity. NY says, doesn't a lie have to be determined by a court? His argument is circular, but by what basis does he call Trump's speech lies? Well, I guess it's the official findings, right? It'd be like the official outcome conclusion is that he lost and he says he didn't. And so he's challenging that. So therefore he's lying, I guess. Now, our argument is no, because that's not a legitimate outcome. eGrab on Rumble says he was the president. How can he be charged with impersonating an officer or making false statements to the government? What the actual heck? Yeah. And that's basically what Sadow's saying, right? It's part of his duty to get out there and make sure the election is not rigged. NY says Stacey Abrams asserted falsely she won the governor office. That's a lie. Where is her prosecution? Good question. Cindy says the president didn't lie. Every attorney who has not read the debunked and is working on this case is doing a disservice to all involved. They will immediately see the fraud in all 6 states and the info President Trump had for his statements that are not lies, but are in fact truth. Just Me says when Trump was making the speech, he was the chief government officer of the government. He was the government, and nothing was done to find, in fact, whether his statements were false. Yeah, I agree. You had guys like Bill Barr who just basically delayed or deflected any prosecutorial or any real legitimate investigations into what actually happened. Mika's here. What's up, Mika? Says, Robert, please remind us, is this case laid at Trump as a civilian or as a president? Thank you. Well, I'd say as both, right? So it was conduct while he was president. It was conduct while he was a civilian after the election. But I think all the conduct is probably before he left office. Was there conduct alleged after he left office? but as both, right? I mean, basically both, right? It's one set of laws. He's being prosecuted in the criminal court of law as a former president, but it's a crime. This is not civil law at all. And this is not impeachment. This is a criminal court in Georgia. Philip B says, how can challenging an election result be a crime? Well, it's when you have dictators in charge who do not want you to challenge their election results. I mean, that's basically what it is. When you live in a totalitarian type society and you can't challenge your government, that's what we get. Ike's Girl says, is Floyd the White House attorney assigned to Fani? If not, who is? No, you're probably, no. I mean, there was no real White House attorney that was assigned to Fani. I mean, there was one other guy that was called DeSantis, not Ron, but someone else was called DeSantis, who I think that's who you're talking about, but it wasn't Floyd. Floyd's the other RICO guy who was assigned as special counsel. Philip Butler says, challenging electors is legal since the very first election. Yeah, well, a lot has changed in these last several years. So 2024 is going to be a whole different ballgame where now you prosecute people like you did in 2020. NY says, I see the chat trying to make sense of this all, asking, can't police legally lie? Yeah. Don't even try the case in Georgia is a novel tortured lawfare exercise. It's not rational. It's not logical at all. Jigam Gigam is here, says, don't forget to smash that like button, baby. Thank you, Jigam, for the good reminder. Smash it, my friends. Trevelyn Gale. What's up, Trevelyn Gale? Very nice dono. Thank you for saying that and for being here. Hey, you, Trevelyn. Hey, you back. Joseph C. says, why isn't he using the defense that competing electors have existed in multiple elections since the founding as part of election contests? I think we heard a little bit of that from Shafer today. He was saying that there was a safe harbor, provision. They basically had to get their position in, and they did so according to the law. Philip B says Congress determines which electors are legitimate. Yeah, and that was the argument. And now, right, they've kind of changed that up a bit. Well, actually, they were going to say that Mike Pence had that authority. Mike Pence said, I don't have that authority. Then they changed it, and now it's just basically ceremonial, right? Now the VP just accepts whatever they get. But there was a debate about this. The question was, could Mike Pence actually make that decision? Roy MC says, okay, so in a two-horse election race, only the winning party nominate their own pre-agreed electors, meaning that every other group pre-election are criminals if they don't win the election. Yes, if you apply the Fani and Liz Cheney standards, yes, they're all criminals immediately. Essential Bites says, OMG, Rob, please tell us what these ramblings mean. I mean, the second defense lawyer, all I get is, wah, wah, wah. It was kind of a thick day. There was some thick stuff that was going on today. Might have been more useful for us to go through those motions first, but hopefully it made sense after we went through the second motions. We kind of filled in what we were talking about. NY says, I've noticed in many small ways that Judge McAfee drags the prosecution over the finish line. I think it's because he's a prosecutor at heart. Many times when the prosecution chokes, he helps them. I Am One says, how can the court not see just how idiotic this whole case truly is? It's just ridiculous. I think you're right about that. I think that we're now in the middle of what is clearly a political case, much more so than it was a legal case. We're constantly like ebbing and flowing between the court of law and the court of public opinion. We were hopeful that McAfee would still keep this in the court of law, but that's not where we're at. It's just a political hit job, as we've seen. Joe Sapp says, based on the search results, an elector is not necessarily a state official, but rather a person selected by the political party of the presidential candidate to represent that candidate in the electoral college. The political parties in each state choose slates of potential electors before the general election. Electors do not have to be state officials, but they cannot be U.S. senators, reps, or anyone else holding federal office of trust or profit. Good one from Joe Sapp. Essential Bite says, I just love this family. It's so fun to play with the team. It is fun, Essential Bites. Thanks for being a membo. Thanks for being here, hanging out with us. It is fun. It is fun to go through the day's activities together and see what's going on there. We got Milo Phone Bill says, In 1651, anything besides this was a lie. Any other opinion counter to the government and the religion was heresy. Galileo was jailed for his ideas. This is why we need the First Amendment. Exactly right. Listen, I want to hear from all the wrong idiots. I want to hear from them. I want to see all their wrong opinions out there all over the place so that we know what's going on. Censoring that provides us of that useful information about not to do that thing. Like you want to see somebody else make a mistake so you don't have to make that mistake. If you can, learn from them. Don't do it yourself. James Law. What's up, James Law? Welcome aboard. Our newest supporter. NY on Local says, I agree that prosecuting this Georgia case is a conspiracy to deny the defendants their constitutional rights, which are free speech. And I also argue that they were on sufficient notice from case law. Even prosecutors lose their qualified immunity in all of them. Even that guy in the tight suit can be prosecuted. This old guy says Georgia will forever be labeled a backwater state if this case is allowed to continue. Crash says, Rob, was Judge McAfee alluding to a directed verdict, an indication of where he was leaning? No, I don't think so. No. If he impanels a full jury and we get there, he's not dumping this case there. Meaning that he needs to hear the arguments and the testimony before having enough to dismiss or direct a verdict of acquittal? I don't think so. I think he just doesn't want to make a decision on this, and he's trying to figure out where to make that decision. We got this one from NY says, tell this to everyone, specifically Shafer. He was charged because he was elected as a Republican Party elector. Imagine what is the Democratic Party's next trick. They imply it in almost every statement they make. Republicans in an ideology and thought they are criminal. I've listened closely over the years. They are radicals. They are just using the law as a tool to shut down debate by criminalizing it. We got Pamela B says, we the people are paying for all this, so the government has no reason to not keep going. They do want Trump to keep spending his money to ruin him financially. Trump gets creative with sales of things because he's a great businessman, and then they push in smearing campaigns against this. The ends justify the means, just like Nazis, Hamas, and everyone else. That is our Democratic Party today. Yes, and what they're doing is going to have a long, long history of reverberations through the rest of America. The foundations of our justice system are being shattered in real time. Glenn Croy, what's up, Glenn? 11 months as a membo, 1 month more till that 1 year anniversary. Says, Salty Army loves watching the Watchers. And shout out to our friends with the Salty Army. Nice to have you over here. We're grateful to have you. And shout out to the Salty Army. We got Trains Dispatch in the house. What's up, Trains Dispatch? Thank you for the lovely dono. And this one came in as we get close to the end. Cowgirl for God says, little clarification, please. The White House visitor registry showed Fani and Nathan were at the White House, and it showed a military timestamp was the middle of the night, but she claimed she didn't go. Yeah, I think that was Fani saying that she was answering a question about whether she went to the White House. Remember that? Did you go to the White House? And the answer to her was no, I did not. And I think she went to Kamala's, tent. So she was being very careful about that. But you're right, there was some registry logs that Fani was hanging out with VP Kamala. And there was also conversation that Nathan Wade billed for time with the White House counsel. So I think that's some clarity on that one. I Am One says, do you think if Fani not being there is because she doesn't want to continue to taint? Yeah, there's a lot of taint in that courtroom. I mean, Judge McAfee's tainted. The entire prosecution team is tainted. It's very taint-filled there. So maybe she didn't want to contribute to the disgusting taint. But she should have shown up there since she's so tough and, bringing the Fani train over there. Okay, Fani. Okay, Big Fani. I didn't go to the White House. No, I went to a tent right next to the White House. Got it. Very clever. Very, very clever, Big Fani. All right, let's say hello to our friends on X. Then we're going to wrap it up there on the day, my friends. And so, Membos, we're planning on an evening show. Very casual, very light. Just poke around, see what happened on the day. So come join us watching thewatchers.locals.com. UNC Tar Heel fan says Sadow is correct. Is McAfee going to stand tall? No, definitely not. Hey, what's this word? Nuggatory. Nuggatory. I think it's actually nugatory. Hey, what's up, Gigi? Kathleen Hastings, Renato's in the house. We got Blocksoft, Hip Hop Thinker, L's in the house. Brian Cartwright says electors aren't elected, they're appointed by the parties. What's up, Al Holman? And UNC Tar Heel fan says, it's about time someone mentioned the case Trump filed in Georgia, which lawyer Robert Barnes said was strong. That became moot because the court failed to assign a hearing date as required by law. Okay, so shout out to our friends on X. Very nice to see you over there, my friends. We are, of course, later on going to come back and say what's up to our friends on YouTube as members and our locals fam, watchingthewatchers.locals.com. Our website is robertgovea.com, where we have all of our PDFs, show reports, daily newsletter, all free. Go over there to sign up and make sure you never miss a thing. We also have watcherlodge.com, which is where we have our sovereignty and self-development community, where we have forums, workshops, and events. Go check that out at watcherlodge.com. Mama G hosted a Living with Meaning and Purpose masterclass, and boy, was it amazing. And so that, my friends, is it for us on the day. We're going to go say goodbye to our friends on locals for a short bit, and then we'll be back here tomorrow to get into it all again. We want to say thanks to our friends who mod down the fort for us. Vientikis Prime, we got K-Bean in the house, Just Cause, Playing Hooky, Ronnie Cole, our friend Zulu, Beyond Geo, Zach Nichols, John Allen, Janek 909, Dog Digger, and Donut Mind Me, modding the fort down for us. We've also got Sleepy Dog Lee, Nathan N810, and Geegum Geegum memeing the place up for us. Old Coach Crane brought in a new membo as well. Welcome, Old Coach Crane, bringing in what day is it? Roy MC says the question was, did she go to the White House? Not did she go in to the White House? And Trevelyan says all these TDS patients must count their blessings that Trump is a true leader and not a man of revenge, which will be proven after the 2024 election results. Whew, good one from Trevelyan. Yeah, he didn't throw Hillary in prison or prosecute all the Democrats, did he? And so, my friends, that is it for us on the day. We are going to go over to watchingthewatchers.locals.com to say goodbye. Then we'll be back there later on in the day. But that's going to be it for us on the main program today, unless something else explosive happens and we can't resist. But we'll be back in the morning, back tomorrow for the regular show. Regular time. Actually, it'll be 1 hour later tomorrow. And we'll be back to see you tomorrow. And so we'll leave it there on the day, my friends. I hope you have a beautiful day. And I hope that you come on back here tomorrow, because we need to see you right back here so that together, with your help, we can shine that big, beautiful spotlight of accountability and transparency down upon our system with the hope of finding justice. Make it a beautiful day, my friends, an amazing Thursday. We'll see you right back here tomorrow. Bye-bye.